is now open. Please be seated. Good morning, Ross.
Good morning. Good morning. Welcome to the Appeals Court. Let me introduce the panel. To my right is Justice Ditkoff. To my left is Justice Brennan. And I'm Justice Shin, and we will be your panel for all six cases on the list today. The rules of oral argument are, as I'm sure many of you know, each side gets 15 minutes to argue. You don't have to use all your time if you don't want to. Otherwise, when the yellow light goes on, you should start trying to wrap up your argument, and when the red light goes on, it means your time has expired, and we do not allow rebuttal in the appeals court. And the last thing I'll say is the panel has read all the briefs. We're familiar with the record, so I'd urge you to get to the heart of your argument. So I understand we're taking the cases out of order. We're starting with case number 2, which is Commonwealth versus a juvenile, number 2023 P1151.
Good morning. May it please the court. Jennifer Cullen for the Commonwealth. The Commonwealth argues that, consistent with the community caretaking function of the police, the exit order and pat frisk given to the juvenile in this case were reasonable actions, given the unique set of facts here, and the motion to suppress should have been denied. I am, of course, before you with an argument on how I believe the court should decide, but I think this is an area of case law that hasn't really been discussed, and I am asking for the court's guidance. First, the first issue that I raised pertained to 2 findings that the Commonwealth would ask your honors to find were erroneous, as they were not supported by the testimony, or the court should find that upon reviewing the entire evidence, the court's left with a definite and firm conviction that a mistake has been made. The first finding was that the officer's testimony was he did not call the juvenile's custodian because he viewed the situation as a traffic stop. And the second erroneous finding in the Commonwealth's perspective was that the officer was not functioning in a community caretaking capacity. Turning to the exit order and the stop itself, the Commonwealth argues that the most important facet of this case is the fact that this was a missing juvenile. And while the stop did begin as a lawful stop pursuant to a motor vehicle traffic infraction, the situation evolved once the officer recognized the missing juvenile in the back of the car.
Counselor, do you believe the standard for community caretaking is subjective or objective?
I believe it's subjective, Your Honor. And I believe it is based on objective facts indicating that someone needs medical attention or other assistance which supports police intervention. And again, I think here asking the juvenile to exit the car was reasonable given the fact that he was missing. And I think that you could look at that fact in a vacuum and still find that it was reasonable to have the juvenile exit the car.
Is it a finding of fact, or is that a legal conclusion? Whether it's a community caretaking?
I would argue that whether this was a community caretaking function is a conclusion of law and not a finding of fact.
But the judge made it a finding of fact in this case?
Yes, and I would argue that she did discuss the community caretaking function later on in her order, and I think that it was properly addressed in that section of her order. As to the frisk, when I was considering my argument on this, I think it was important to think of hypothetical situations that don't really match this one. And I thought about whether the same actions would have been reasonable if this was a 10-year-old instead of a 17-year-old. And I'm not sure that it would be reasonable to frisk a 10-year-old. And that's why I think that this situation doesn't squarely fit within the reasonable suspicion of an individual being armed and dangerous, because this wasn't an investigation. But I think there were factors that went towards the officer's safety concerns, which made it reasonable for them to frisk the juvenile before they put him unhandcuffed in the backseat of their cruiser.
So how do we, if it's not normal Taurus Pagan reasonable suspicion, what what is it? What's the standard for deciding whether you can pat frisk someone in this situation?
Your Honor, that is where I was kind of at a loss because, again, I didn't see a situation really analogous to this in the case law, which is why I kind of compared the situation to a protective custody situation. So under Chapter 111B, Section 8, I believe that the police are able to frisk an individual prior to transporting them if they reasonably believe their safety or safety of other persons so requires.
So you're not taking the position that it is inherently dangerous anytime you place a person behind you in a cruiser if you're the police officer?
I think that there is an argument for that. I think that the police should not have to disregard the fact that there is going to be an individual behind them that's not restrained. However, again, when I look at it as a 10-year-old or an 87-year-old.
And where do we draw the line? So, for example, what if we were to say it's a right, if you will, but not a requirement? Because I think we can agree that the police haven't. Well, let me ask you one question at a time.
I agree, Your Honor. And I think it should be discretionary, and I'm not sure what that standard should be. But I think at least in this situation, there were facts that reasonably caused the officers to be concerned for their safety in this particular situation. So I'm not sure what footing that leaves other cases on or a standard overall, but I would.
What if you had a child that was acutely mentally ill and exhibiting symptoms out in the street, and so it's essentially a 123.12 transport on an emergency mental health issue? In that situation, do the police have the right to pat down a person before they put them in the back seat? Or, again, is it the sliding scale or some sort of a nebulous area here?
I think the court could find that a frisk can occur at any time. But again,
I think it's important to give the police a bright line on this, one way or the other, to give them very clear direction on this, or do you think, again, it makes more sense for us to be a little more flexible in that?
I think flexibility is important, and I think that kind of controls the entirety of this case. This isn't a black and white situation. I think that's exhibited by the fact that the community caretaking function and the investigatory function are, I think the court has said, imperceptible, the difference is imperceptible. Like, they're so very close, and it's so fact-dependent.
Would it be an objective standard or a subjective standard?
I would argue an objective standard.
Objective standard, whether it's reasonable that the officer had fears for his own safety.
Yes.
Or presumably the safety of anyone else.
Yes, Your Honor.
So if the person was unconscious, they'd be able to frisk them before they put them in the back?
Well, I suppose this raises another question that kind of goes to the reasonableness of the policy on the missing person, and that was something that I considered. If the police had come upon this vehicle and it was a crash and the juvenile was unconscious rather than a motor vehicle stop, I think there's discretion in the policy because obviously the first concern should be medical attention and shouldn't be calling DCF or a guardian or not moving them so that the guardian can come to the location. I think that in that situation, medical attention is required. And because it's a community caretaking function, I don't think that the police would be considering frisking the individual at that point.
Well, I'm assuming someone's unconscious from an accident, they probably wouldn't be put in the back of a cruiser. But let's say it was someone who was overdosing and was unconscious. What about that?
I mean, if they had to frisk them in order to ascertain if they believed that they were overdosing and had to know what they had taken or something, I think that would be reasonable. I guess it's hard for me to imagine a situation where there's a medical emergency and the police would be putting the juvenile in the back of the cruiser as opposed to waiting on scene for EMTs or.
Do you have any sense whether the cases from other jurisdictions are consistent on this issue?
Your Honor, I could only find the New Jersey case, State and De Loretto, as kind of in line with the fact pattern here. And I think I would ask Your Honors to use the reasoning that was applied in that case. I think it is helpful, obviously not precedent, but I think it is a useful way of reviewing the situation because the facts are so similar.
Turning to this case, if we were to accept that there has to be some objectively reasonable indication that the juvenile was a danger, what would you point to on the facts, at least as found by the judge, that would lead us to that conclusion that it was reasonable here?
So the judge did find in her facts that the individuals had been ducking and looking back when the stop first occurred.
Did she find ducking? She mentions that the officer testified to that, but it seemed like her findings were the only thing he was doing was looking back.
I did notice that, Your Honor, but I would argue that where the judge did make a credibility finding, although I do disagree with it, she was very explicit when she was making a credibility determination, and she didn't make her determination in the same way here. I saw...
Was there a general credibility finding? There might have been. They always blur together at this point.
It was, I believe it was a credibility finding as to the fact that this officer had heard one of the individuals in the car was seen on social media with a gun. I believe that's what the credibility determination pertained to. So I would say the furtive movements at the time of the stop, and I think even disregarding the individual who's a gang associate, I think where you have a missing person, that can be a very volatile situation. As my brother counsel brought up, we don't know why a person is missing. And I think that makes the situation unsafe for the missing person who may not want to be found.
Does the length of the time the child was missing factor in at all here?
I don't think so, because I think
Okay.
factoring that in, the officers should have protected this person's safety regardless of how long they were missing.
In terms of assessing the volatility or the risk of putting the person in the back seat, does it make a difference if the child was missing for 2 days or, as it appears here, for a minimum of 6 months? Or maybe a maximum of 6 months, I'm not sure.
I'm not sure, Your Honor, because I think, I mean, at that point, I think he probably wants to stay missing. We don't know why. I don't know how that goes. I'm not sure. I honestly haven't considered that.
In what import, if any, does the finding or the fact, if you will, that the juvenile is seated next to a Trinitarios associate, which is just another way of saying is a gang member, and that person was seen at least at some point on social media with a firearm, allegedly?
I think that factors in. I think I did feel I had to consider what the judge said about the social media post. I think I do disagree. It seems to me that her statements pertain more to the weight rather than credibility. However, if it is a credibility determination, I accept that. I think it is concerning that this juvenile is found in the backseat with a gang member. I don't know. I guess that coupled with the furtive movements can say something to the officer. I think also the fact that this is a missing juvenile who's in the presence of a known gang member could make the officers more concerned about getting the juvenile out of the car in the first place. I think it is a consideration.
What if this were a missing adult? How would the outcome of the case change, or would it? Because it was very hasty.
Yes.
The frisk, right?
I mean, obviously, we, I think, treat this sort of a situation perhaps more seriously because it is a child. However, I think that any missing person should be treated with care, and I think it really depends on the situation. I think in the New Jersey case, the car in which the missing person was found was in a parking lot. It was a different factual scenario as to how the officers found the person, and I think there the officers made a point of doing more checks in the car, and I think that was perhaps because they had more time. They're in a parking lot. There's not moving traffic.
Let's just assume the exact same facts, except that it's a missing adult rather
I
than
think
a
that they
juvenile.
could
So-
act in the same manner.
So they can order someone they believe to be a missing adult out of a car and immediately pat frisk them without conducting any additional inquiry.
I think it's possible. And whether that's because they plan on, I think the problem in this scenario is also we don't know exactly what would have happened or how the situation would have played out had a gun not been found, but I think it would have been reasonable for the person to be frisked, separated, and asked some questions roadside, maybe not transported immediately back to the station if this was a missing adult.
Counselor, just
Nope.
just one technical point. Your appendix doesn't have the indictment, and we need that to caption the case.
Oh,
So
I
you'll need to-
apologize, I can provide
No big deal.
that.
You just need to supply that to us.
Yes, I will send that.
I do have one more question, and that is just to follow up on Judge Shin's question. Does the statutory authority to, in some circumstances, take custody of a child make a difference here? And as an aside, I know it is a child that's not going to be summoned. I'm not sure where you send a summons to the missing child mailbox, but putting that aside, does that make a difference here? Because it strikes me that taking someone into custody would be different if we're an adult, but perhaps not.
I think that the issue, it is still the fact that this is a missing person. I think that still controls overall, and I think the safety concerns for that person, which might entail transporting them elsewhere to be able to speak to them further. I think that.
But the justification for the frisk, you're saying, is the need to put the person in the cruiser.
Yes.
So if it's an adult and you might put them in the cruiser, how would they be justified in frisking them?
That's a very good point.
Because I take your argument to be that once the officer, he immediately recognizes this juvenile to be the missing child, that at that point he knew he was going to have to put him in the cruiser.
Well, I think you could have a situation, as in the New Jersey case, where there wasn't an intention to transport the person to the station. However, they did intend to put the person in the back of the cruiser. And I think there were weather considerations there. But I think there is a scenario where it's safer to put the person in the back of the cruiser, where you then might be sitting on your radio, contacting the station or making other contacts. So even though you didn't plan on transporting them, I think the frisk would still be necessary.
Thank you, Counsel.
Thank you.
Good morning. May it please the court, Dennis Toomey on behalf of the juvenile. We're asking you to affirm. The motion judge correctly concluded that the police officer's warrantless actions violated the juvenile's constitutional rights. The officer admitted the reason for the exit order and pat frisk was he was taking the juvenile into custody for being a runaway. There was no reasonable suspicion that the juvenile was armed and dangerous, and that was a requirement here. Nothing the Commonwealth has pointed to says that we throw the Taurus pagan standard out the window when police want to seize a juvenile runaway. The Commonwealth claims the community caretaking exception or function cures all the actions here, but there are several reasons why it does not. First, community caretaking is supposed to be about offering assistance in a manner that is totally divorced from any criminal investigation. Now here the officer never offered to help my client, never even said a word to him. But Judge Karen Hennessy, the motion judge who heard the live testimony, she made a finding that the officer's actions were not totally divorced from criminal activity. He was investigating the social media tip about the gun that the adult passenger supposedly had on social media at some unknown date.
So do you disagree with your friend that it's an objective standard?
I believe it has both objective and subjective components. I cited Smigliano and Knowles, and Smigliano says that the judge has a duty to determine whether the police conduct was actually bona fide community caretaking or not. So I think the judge can and did make a credibility finding about whether the officer was being truthful about his reasoning or not. And then Knowles, though, 451 Mass at 95, does say that also an objective view of the action should be taken.
But is it with respect to the person, right? So officer might have wanted to investigate the other person in the back seat, but with respect to the juvenile, what was his investigatory intent? Because the judge found, as a matter of fact, that once the officer saw the juvenile, he immediately recognized him as the missing child.
Yes.
Okay, so why isn't it with respect to the juvenile, why isn't he then acting in his community caretaking role?
Well, the officer used his mistaken belief that he could take the juvenile into custody to expand the scope of the traffic stop to also search and frisk the adult passenger Montilla.
Okay, but once he recognizes the juvenile as the missing child, and then he orders him out of the car, at that point he is acting in a community caretaking function, right? With respect to the juvenile, putting aside the other person in the backseat.
Even if that were true, that's not a proper community caretaking function here. Police cannot seize a first-time voluntary juvenile runaway and take them into custody. There is no constitutional or statutory authority. In fact, there's statutory authority to the opposite.
Well,
The CRA statute says a voluntary juvenile runaway has to be a repeated runaway, then they have to
okay,
initiate
but
a CRA petition.
how do we know this is a runaway?
The police bulletin, which is at Record Appendix page 20, the police were specifically informed that this was a voluntary runaway from his foster home. It's not a missing person. That's what keeps getting thrown about, and that's why this is different from a toddler who might wander off into the woods or a kidnapped 8-year-old. The bulletin that the police had says this juvenile was 16 years old and he ran away from his foster home. So it's not a missing person. And the Lawrence Police Department policy differentiates between voluntary runaways and missing persons. And this is Record Appendix page 30. The Lawrence policy says if you're a voluntary runaway, the officer should call the parents and tell them to start a CRA petition if it's appropriate.
They did call the parents, right?
They called the guardians after the juvenile was taken into custody.
Right, but
This
there's
means-
nothing in the policy that prohibits them from taking the juvenile to the station, right?
There's nothing in the policy that authorizes them to take
That's
them to the
right,
station.
but it doesn't prohibit it either.
Yes. But what I meant to say, the officer is supposed to call the parents when the juvenile is reported missing, not just at the scene. That's what their policy says. When you get a report of a missing juvenile that's a voluntary runaway, you're supposed to call the parents and say, start a CRA petition if you're able to. Because that's the only thing that gives police authority to seize a juvenile runaway. The legislature has spoken on this.
Wait, if someone runs away from DCF custody, you have to call the parents the child's been taken away and ask them to do a CRA petition?
In this case, it would be the guardian, so it would be the group home, foster home head could call as well.
So the DCF tells you someone's missing, and then you need to call the DCF person who called you and tell them that the person's missing? I'm not
No, you
following.
need
I'm
to
not
act-
following this.
You need to
No,
tell them-
I really just not. I'm not following.
You need to advise them to initiate a CRA petition if it's the second time that they've run away. Because that's the only authority that police have to take a juvenile into custody for running away. Running away is not a crime. And he was not in any danger, so there's no emergency aid exception here. So the police did not have the authority to seize my client, to pat frisk him, and to throw him into a cruiser for running away from home at age 16.
What about, and I just don't have in front of me the portion of the statute that says a missing child who is not responsive to summons?
Yes, that's the CRA statute as
Right.
well.
And so could the police not infer that someone who's been missing for over 6 months, or actually maybe a year at this point, or when was it? Well, let's just say at least 6 months, that this is not someone who should at least be taken into some temporary custody?
Well, the statute requires that they at least try the summons. I recognize your question before that it's unlikely to be received. But then there's a standard within the statute that says the officer has to testify that he has probable cause, that there's no other way to get him there. That didn't happen here. So
Let me give you another scenario. I'm trying to make sense of this. So if this were hypothetically, and I only use a young female because statistically more susceptible to exploitation. Say it's a 15-year-old girl in a car with 3 adults who's been missing for 6 months. And the police look and say, oof, what's going on here? Gee, is she being exploited in some way? And they say, oh, not much we can do. Just carry on. Have a nice day. And then you learn that the driver of the car was her human trafficker at some later date. You think that is an appropriate and responsible response by the police or consistent with their obligations?
no. So as an initial matter, I'm hesitant to get away to all these hypotheticals because this is a simple case. But the officer in your hypothetical could ask the runaway juvenile if she's okay, if she needs assistance.
In the presence of the 3 adults?
Even if an exit order was granted to talk privately, that doesn't get you to a pat frisk. Right? That's I think the key.
Okay, so you're okay then, so we can get to the exit order. At least separate the child from the 3 adults. We're good with that.
Even assuming without deciding that's true,
All right.
you still can't do a pat frisk without
And in
reasonable
some sense, that's custody. I mean, you're taking the person into custody, right?
Well, I wouldn't.
If you're taking them out of the car,
I don't
to
know that-
separate them from the 3 adults that are in the car.
In most cases, an exit order doesn't mean custody. I think that you can give an exit order and just have a conversation outside the car. Officers do that all the time for safety reasons. But to get to a pat frisk or to custody, it's another jump. And they didn't do that here. That's why this case is simple. The pat frisk
Well,
wasn't
so you're
tested.
saying even if an officer is legitimately acting as a community caretaker, that they can't frisk someone that they have to put in their cruiser unless they can satisfy Torres Pagan?
I'm saying here that they didn't have the
No,
authority
just as a general matter. So let's say you have someone who, late at night on the side of the highway, who's clearly suffering some sort of mental episode. They don't want to leave the person on the side of the highway in the dark. So they want to put the person in the cruiser. In that situation, they're not allowed to frisk them before they put them in the back of the cruiser?
Again, that's not an issue that was raised by this case, so I haven't researched it fully. I would just say that the officer here needed a reasonable suspicion that my client was armed.
And that's because it wasn't legitimately community caretaking? Or are you saying as a matter of law, even if it's legitimately community caretaking, you still have to satisfy armed and dangerous?
I would press the position that the Torres Pagan standard should still apply.
So
when a
even in
juvenile
my
runaway-
hypothetical, if there's no facts indicating the person on the side of the road is armed and dangerous, they can't frisk the person before putting them in the cruiser?
That's my answer to your hypothetical, yes, Your Honor. Although, again, I have not researched that because this case does not present that question.
Does the police, we'll call it knowledge, that one of your client's companions was a Trinitarios gang member, factored all into their evaluation as to whether the child needs some sort of at least initial protection or some assessment as to whether the child needs protection?
No. The judge did acknowledge there was testimony that the adult passenger was associated with a gang. There was no testimony about what that meant, but
Okay.
they didn't even know if that was his family. I mean, that could have been his uncle or his father for all the police knew. They never asked. But the case law, again, is clear that even if the juvenile had been a gang member and he wasn't, that's still not enough to pat frisk someone. You have to have reasonable suspicion that they're presently armed. So the gang membership here did not move the needle for the judge. I do want to address Justice Ditkoff's question about the ducking down. The judge did not credit the officer's testimony that people were ducking their heads in the car.
Well, at least didn't find it as a fact. I mean, It wasn't a statement that she specifically discredited, was there? I don't remember.
Not explicitly. She was very respectful and subtle about not calling this officer a filthy liar. She was very careful in her findings, but she did say,
Would she have had cause to call him a filthy liar?
well, she
On
did
the
believe
facts,
that,
on the
she did
transcript
believe
on the
that
facts here?
he was not truthful in several regards, not just the social media tip. She found, and this is what she said, despite his claim that he was concerned for his safety, his actions suggest otherwise. She found that the movements in the car were just heads turning back to look at police. She specifically used the phrase "he claimed" when describing parts of his testimony about heads moving.
If there was investigatory, I guess, I mean, who knows, but why wouldn't they pull the guy out who supposedly had the gun first?
Because they were looking for the gun based on the social media tip, not because of safety concerns.
No, so why wouldn't they have pulled out the guy who allegedly had the gun instead of your client who's...
They did it both. The testimony wasn't clear.
Well, after they find the high-capacity semi-automatic on your client, and they pull the other guy out. That's a little different.
I think the gist of it was they were going to do that to Montilla no matter what. I think that's what this whole thing was about, not helping my client.
And why, and I understand the judge's findings, but it just seems to me that, as in many of these situations, lots of things can be going on at once. You had a traffic stop. Now, was it pretextual? Was it because they saw the kid they knew was a gang member in the car a few hours earlier? Maybe, but still legal. And so are they going to write her a ticket for rolling through the stop sign at the same time, keeping an eye on the guy in the back seat who maybe had a gun, and then they realize that the other person in the car is on the bolo from that morning? Lots of things going on that the police have to assess, and why do we have to compartmentalize and narrow it down to this was their sole purpose, that was their sole purpose? Just doesn't seem to make a whole lot of sense to me.
Well, the community caretaking function says it has to be their sole purpose. That's the case law.
As regards to that particular individual,
Yes.
but not the sole purpose of, I mean, again, presumably we can permit police to multitask.
Yes.
And does multitasking in and of itself then suggest that as it relates to an individual, their purpose was not singular? And I'll put that in plain English. Just because they may have been investigating other things, does that mean that their purpose with respect to the child was not community caretaking?
That's my argument, that it was not solely community caretaking, and that the reasonable suspicion standard for pat frisks did apply, and it was clearly not satisfied. In fact, the Commonwealth's argument today seems to concede that this was done solely for the taking him into custody and not because he was armed. The officer never really thought my client was armed.
Well, if it's objective and you have a missing 16-year-old with, as far as you know, strangers, why isn't it reasonable to take that person out and transport them to the station and call the proper, group home or whatever, and arrange for that person to be brought there?
Again, I would go back to the CRA statute, which says police can never transport a runaway juvenile to the station. Never. If the juvenile is a repeated runaway and a CRA petition has been initiated, they can bring them to a shelter or to their guardian. Or
the
keep them there.
problem with putting all your eggs in that basket is we have no finding that it was persistent runaway that was the reason why he was taking custody, which is what the statute says. And to base it on an exhibit that the officer specifically said he had never seen and was not the one he'd saw that morning doesn't get us that far, which is why I'd like you to, you keep your eggs in that basket too, but I'd like you to move some eggs into the unreasonableness basket.
Sure. But again, it was the Commonwealth's burden at the evidentiary hearing for all those things that you just mentioned, the updated bulletin, if there was one, any evidence about whether a CRA petition was pursued or whether there was a repeated runaway. They didn't introduce that evidence, so they failed to meet their burden to justify it. But the actions were unreasonable here. They were unreasonable because the officer never asked my client any questions. Even when he pulled him out of the car, he never said, hey, are you this named juvenile? Are you still running away? Are you in any danger? Are those guys messing with you in any way? Is that a gang member? Is there any guns in the car? Anything. He didn't do any of the typical community caretaking questions that you would ask a runaway. And so the actions were unreasonable. And when my client was out of the car, he was acting calm, cooperative. There was no bulge. He wasn't blading his stance. None of the factors that this court and the SJC have said might justify a pat frisk, none of those factors were present. So the actions of the officer, warrantless actions, they were unreasonable, and the motion judge got it right. I can see I'm out of time if there's any questions.
Okay, thank you
Rest
very
my
much,
brief.
counsel.
Thank you.
Thank you both. The case is submitted. Do we have the attorneys for case number? Okay. The next case is Commonwealth versus Robinson, number 2022P320. Counsel.
Good morning, Your Honors. May it please the Court. Jennifer Peterson here today on behalf of the defendant appellant, DARCYLE Robinson. Your Honors, this case turns on the issue of consent. And it's axiomatic that in cases of indecent assault and battery like this one, the Commonwealth bears the burden of proving beyond a reasonable doubt the lack of consent. And here, the evidence was simply insufficient to prove that there was a lack of consent. Instead, the evidence showed that my client and the complainant met on Facebook, where they shared a lot of mutual friends. At the time, she was 15, he was 22. They messaged each other, they flirted for a couple months, they sent each other Snapchats, partially nude and nude Snapchats, and eventually she invited him over to her house, and one day when she was home alone, and they sat and talked and eventually kissed. A few more weeks went by, and they arranged to meet again, and she decided to skip a school field trip, and she had him over, and the plan was for them to come over and hang out and watch TV, they did. They sat down, they started talking, watching TV, and eventually he asked about having sex, and she verbally said no, she wasn't interested, she was menstruating, no. So then it went on, and he asked about oral sex. And her testimony was, he wanted oral sex, and I didn't really say anything. I didn't know. It went quiet after that. And then eventually he put his arm around me, was moving me closer to him, and then he kind of just guided me to his lap. He pulled out his penis, he put my head down toward it, and once it started, it never stopped. I wanted it to stop at one point, but he didn't. He
All right,
just
so
kept
I
pushing.
wanted it to stop. That sounds like lack of consent. Why can't a jury believe that and find she didn't consent at that point? Anything
I
after
would
that?
suggest that if at that point she's withdrawing consent, that there needs to be some sort of clear, objective indicia of non-consent. And just because she said she felt something doesn't mean it was in any way communicated to Mr. Robinson.
What do you do with, I think it's sure that the Commonwealth cites, it says, law doesn't require explicit or physical rebuff to prove lack of consent. That, for example, when she tried to pull her head up, or after she vomited and tried to extricate herself, that the pushing of the head down.
Well, I would suggest that her testimony suggested that that was happening the entire time. She said he was thrusting and pushing her head down over and over and over again. So she said there was one instance, and she specifically just said, there was one time I put both of my hands down and pushed up, and he pushed me back down, at which point she said she threw up. And from the context, it seems more of a spit up than a throw up. I mean, they referenced at the end that there was a damp spot on his jeans from that. But there's nothing to suggest that he was aware in that context. She didn't push herself away. In fact, she said that her testimony was actually that after the single push-up, things continued as they had been. Her head was down, her hand was on it, and she was just going with it. Just going with it, she said.
Again, all great arguments for the jury, but if we're taking this in the light most favorable to the Commonwealth as a matter of law, why is her pulling her head up and getting it shoved back down not something that a rational juror could infer exhibited lack of consent?
Well, I would suggest the evidence didn't suggest shoved back down, or that anything
Pushed
was
it.
happening that he pushed, but that he had been pushing her back down. But there's nothing to suggest, and they really need to prove, and I think that's the point here, that there was objective indicia of non-consent. And how did he know in that moment that she had decided to withdraw consent? And that's the point. How would he know? She didn't stop. There was one issue, and so from that, was he supposed to infer? I mean, that's what the Commonwealth's argument would be.
Why does there have to be objective indicia of non-consent? You keep saying that, but where are you getting that from?
Well, you know, there's either going to be, we would suggest that there was actual consent here, and that there's no question about whether or not, you know, this is a situation where that there is some kind of assumed consent, or that he had a good faith belief that there was consent. But we would argue that in the face, if this court decides that there was an actual consent here, or if somehow the consent was withdrawn, that the evidence shows that he was warranted and had a good faith belief that consent existed. And so if he had a good faith belief that consent existed, then the Commonwealth needs to present evidence that there's no clear objective indicia of non-consent, because how else do we know but to communicate non-consent? And clearly she was able to communicate that she didn't want intercourse, and she was, it seems to be vaguely, you know, equivocal about whether or not she wanted oral sex, but then she decided to allow him to put his arm around her, move her closer, and there was no pushback at any point. In fact,
Well, there was literally pushback. I mean, she literally pushed back.
Well, technically, yes, but that was over and over and over again pushing back. She said he was thrusting over and over and pushing her head down over and over again.
I threw up,
Part of the
I
act.
threw up, and then that is when I tried to push myself off. That's 166.
Yeah. But then she said, but he had his hand on my head, so I was just going with it. She said,
Yeah, it's not uncommon for people to eventually realize the rapist isn't going to stop and stop resisting, but I don't think that's a defense.
yeah, I don't think that the context here suggests that, though. I think in the context here doesn't seem to suggest that she decided to just back up and say, okay, this guy's going to rape me, and this is the end. I don't think that the context here was that at all.
When you say you don't think that, why is that not a question for the jury?
It is a question for the jury, but the burden of
So
proof
if it's
is on
a
the
question for
Commonwealth.
the jury, then it means it gets to the jury, which means you can't have a required finding, presumably.
Well, I would suggest also the jury had questions and specifically came back and asked for a copy of her testimony,
Right.
which of course was, you know, they did not have a copy of her testimony, so that they couldn't review it. I would also suggest that her behavior afterwards is indicative. It gives more context clues here. And her behavior afterwards, they continue to stay in contact for about a month afterwards, and then things kind of seem to fizzle out. And it wasn't until a year and a half later when one of her friends, I guess DARCYLE texted her, and the name popped up just in on her phone, and a friend saw it and said, who is this person? How do you know him? And, you know, they found out it was the same DARCYLE that she was aware that her mentor was engaged to him. So she took screenshots of the complainant's phone and showed them to Mr. Robinson's fiancée at the time, and then they tried to set him up to show that he was willing to cheat.
And that, just so I'm clear, that says what relative to
It's
her
relative
lack
because-
of consent
because
as a
it
matter
was-
of law?
It was the fiancée who went to the police. It
Okay.
wasn't the complainant who went to the police. In fact, she said how surprised she was that the police showed up. The fiancée ostensibly went to the police as her role of mandated reporter, but, you know, she actually requested, the mandated reporter actually requested her friend, the complainant's friend Alexis, to try to set him up to show that he was interested in cheating or that he might be willing to cheat on her. So,
But again, so why?
this is just part of the context as to why this wasn't seen. I mean, ex post facto, you know, she was equivocal. It seems like the whole situation seems, at best, they showed equivocal behavior. But the Commonwealth needs to prove that there was no consent, and they need to, from an objective point of view, if you look at, I cite the Butler case in there, and Justice Wolhogian, sets out the different standards. I mean, there
Right, and
seems
she
to
says there must be substantial evidence of objective manifestation of consent, not of lack of consent. That's what she says, to even get the defense of reasonable good faith belief.
Well,
I don't see anywhere where she says that there has to be clear and unequivocal expression of non-consent. I think the default is that you're not consenting.
he said reasonably that they have to show that the victim's state of mind are sufficiently equivalent to have led the defendant to reasonably and in good faith believe consent existed
Right.
where it
No,
did
there
not.
must be substantial evidence of that to even get the defense of reasonable good faith belief. That's what she says there.
We're suggesting that it's not even necessary, that there was consent here, and that it wasn't validly withdrawn, that there was nothing from which Mr. Robinson could infer that she was withdrawing consent at the point where she pushed up. And
the consent is the acquiescence, if you will. I mean, she doesn't, not that I'm suggesting that it's required, but she doesn't ever say yes. Well, she says no as opposed to intercourse, but then she doesn't say yes. So you're suggesting that her acquiescence then is evidence of consent?
yes, I am
That's our
suggesting
starting
that.
point. Okay.
Because clearly he respected her boundaries when she said no to intercourse. He respected those boundaries, so he tried. He said, okay, well, how about this instead? And she said she was quiet. She literally testified, I don't know. I didn't know. But she said she didn't know, and those were her feelings, that she didn't communicate that she didn't know. But then her actions, which were she allowed him to put his arm around her, allowed him to pull her closer to him, allowed him to guide her to her lap, and, when he took out his penis, she allowed this to begin. At no point did she say no, at no point did she, except for at one point she decides to pull up. One time. She said, and the prosecutor asked, she said she only did it one time, and then she just decided to go with it. And this is a serious, charge against Mr. Robinson that arose, a year and a half
So what
after.
in your view, what do you have to do in this situation? One push-off isn't enough? You got to push off 2 times, 3 times? When does it stop being consent, in your view?
I think she could have just stopped. There was nothing to suggest that
How
was
would
in
she
any-
stop? His
She could have
penis is
just
being
gotten
put...
up. She could have just stood up. She could have said no.
She tried to, and he pushed her back down.
This wasn't a situation where there was any testimony that he was physically forcing her to stay in place. Did he push her? Yeah, she testified that she was doing it over and over again. So during the consensual part,
She continued to push my head down
Continued.
into my own throw-up.
okay, she calls it throw up, spit up, yes, but
She calls it throw-up.
and
So how isn't that physical restraint? He's literally pushing her head down into her own throw-up and then continuing to insert his penis in her mouth.
I would assert that she consented to being pushed up and down over and over and over again.
But she
and there was
said-
nothing to suggest to him that this had happened.
She said in that moment she used both hands to try to push herself up. Why couldn't the jury find from that it was different than what was happening before and after, that she was trying to stand up?
I don't necessarily know that there was testimony that it was anything different.
Well,
And she
two
did say
hands,
both
two hands. She said 2 hands. One time I put both of my hands down and pushed up, and he pushed me back down. So isn't that different than what you're saying was the...
I don't know. I don't think there was testimony as to exactly how the consensual part was taking place, or when before the consent was allegedly withdrawn. I don't know, because there wasn't testimony, so I can't speak to that. But you know, based on the context of what was happening, he was somebody who respected boundaries, who was somebody who stopped, and there was nothing to suggest that she said no or pushed herself up or said, you know, stop, please. And this is a situation where he had respected. And
So you're almost out of time. I did have a question about the closing argument very quickly, which is, do you agree that there was no objection to the closing argument?
it's hard. Yes, I agree that there's not one on the record. It's hard because this case, as your honors know, there were no sidebars, and there were no sidebars because they weren't recorded due to an error in the court.
But there's no objection on the record.
There's no objection on the record, Your Honor. And just with respect to that, I'd just like to say there were a number, and I've listed them in my brief, but I'd just like to say the Saunders case said, you know, particularly in sex offense cases, there's the potential for prejudice is very strong in these kind of sexual cases, especially in a close case like this, you know, where it involved, you know, two young people and a situation that arrived with charges coming after the fact, a year and a half, in the situation where they did, and where there was a real question, I believe, of consent. And the Commonwealth just kind of seemed to tip the scales a bit too much in this
Okay, thank you.
situation.
We do have your brief on the closing argument.
Thank you, Your Honors.
Good morning. May it please the court. Stephen Nato on behalf of the Commonwealth. First, I'd like to apologize to the court and to counsel for running late this morning. I had an issue with my train station's out of service, so I was kind of acting on the fly. Be that as it may, I'll touch...
We all used to take the T2. Some of us still do.
Not me,
Never will.
if I can help it.
Be that as it may, I'll start with the sufficiency argument. I think Justice Brennan's point is well taken, that my sister's arguments were appropriate for the jury, but under the Lattimore standard, the evidence in this case more than meets the elements, particularly of intent, as to the indecent assault and battery that occurred in this case. Although the victim here acknowledged that she did not verbally decline to participate in oral sex, she did testify to, again, two hands trying to push herself up after she had vomited, in her words, on the defendant as she was going. I know my sister says she did not stop, but that is, of course, on the record, the defendant did not allow her to stop, and that was in the face of, again, objective physical attempts to stop the assault in progress.
Absent, and granted it may be a critical and dispositive absent, but absent the pushing herself up with the two hands, is there anything else that we can look to in the testimony that would suggest a lack of consent?
Well, that she did not consent, that there were no clear indicia of consent.
So is it your position that the initial part that Attorney Peterson has described as consensual was not, again, legally consensual either?
I think that would be a pretty close case, but I think given the testimony where at that point she says he brought her head down, so she didn't say she acquiesced to it, that he sort of pushed her down from the get-go. There was a point later where she says, I just went with it. That's sort of after she's tried to get herself up, but she kind of critically doesn't say at the beginning, I was just going along with it. So I think there's a distinction in her own description of what happens there. But again, all told, on the record and under the Lattimore standard, the evidence of intent and lack of consent was sufficient in this case.
What is your most factually analogous case?
Sorry?
What is your most factually analogous case?
Factually analogous, I don't know, I do, Shore is the case I relied on most, I think, throughout the argument. Butler, proof of force, should negate any possible mistake as to consent. I think within those principles, all stand for the proposition that the evidence in this case was sufficient. If there are no other questions on sufficiency, I'll turn to the closing argument. And I know the defendant raises a number of complaints to the closing argument, and I think the general sort of overarching response to all of them was that this was a closing argument that was based in the evidence at every turn. The prosecutor, from whether she was questioning, does the defense theory that she's lying make sense? She asked the jury to consider that theory in light of the evidence. What is her motive to lie based on her testimony, based on the evidence, based on the circumstances, not just merely that she came into court. Sort of similarly with the kind of running to the final issue, the duty to convict. She's not suggesting sort of a free range. Because you have been seated on this jury, you have some duty to keep the streets safe. You have a duty to find guilt here. You have a duty to bring this defendant to justice. It was, forget her exact words, but if you believe her, that's the evidence you need. If you believe her, you must find him guilty because that's what he is, if you believe her testimony. Similar to the use of first-person pronouns, then it is, perhaps better avoided, but is a sort of common colloquial way of bringing the jury in to consider the evidence. She was not suggesting some, special knowledge of the credibility or the facts. It was, let's look at this piece of evidence. Let's consider this fact. And again, I think the alleged appeals to sympathy, the misstatements, I think were not misstatements. Again, all very much based on the evidence presented. There's no indication of a objection on the record, and to the extent if any of these did cross the line, I don't think they did, but nothing substantial enough to create a miscarriage of justice. If there are no further questions.
Okay. Thank you, counsel. Thank you both. The case is submitted. Next case is Commonwealth versus Thomas CRADOCK, number 2020P748.
Good morning, and may it please the court. My name is Rachel Rose, representing Thomas CRADOCK. A trial judge is supposed to prevent jurors from hearing something that sounds like science but isn't. In this case, what they heard was that a very experienced criminologist had never seen slides that looked like what the defendant's alibi said they were. But the missing link is the one the Daubert hearing is supposed to have filled in, whether that's actually relevant or helpful to the jury's determination. Hair, fiber, bite, and tool mark analyses are all discredited forensic science techniques that were put in front of juries by criminologists. Those techniques have put a lot of innocent people in prison because they thought their experience seeing forensic evidence, where they knew what it was they were seeing, meant they could use that experience to tell things about a sample where they didn't. But they can't. When they try, no two of them agree. There's no controls and no consistent rate of error. They can't do it here either, where the Commonwealth would have cited even one study at trial or in their brief on appeal supporting that categorizing sperm by age based on its appearance is a reliable and reproducible scientific method. The judge's reasoning for abdicating her role in making sure that the criminologist here could do what she claimed doesn't make sense. If she'd stated her ultimate conclusion that the slides were incompatible with CRADOCK's alibi, she'd be invading the province of the jury.
She'd be what? I just didn't hear that last part.
So the trial judge said that she didn't have to qualify her under a Daubert hearing because she didn't let her say that these slides are inconsistent with the alibi. But if she'd gone that far, then that would have been invading the province of the jury. That would have been making a determination.
Oh, invading the province. I'm sorry, I just didn't hear.
Was there this was an alibi? There was a notice of alibi? I just didn't see it.
This was an alibi, yeah.
There was notice of alibi. And then with respect to, because there was some, and I'm not sure it ultimately makes the difference, but there was some discussion about the late disclosure and the fact that this came up during opening statements. Is it your position that part of the defense was, from the defendant's perspective, that he had consensual sexual intercourse with the victim on a prior occasion?
Well, so the prosecution knew very well long before.
Was that part of his defense?
Yes, yes.
All right. And did he file a notice, as is required under the rape shield law, to put the court and the prosecutor on notice of that?
I believe they did. I think they had a statement from him. Certainly the prosecutor.
No, I'm talking about a written motion, as is required by the rape shield law, that the judge can then review in camera, and decide whether, in fact, this is an appropriate piece of evidence to come before the jury.
His testimony that he slept with someone over the weekend before?
That that this victim had a prior sexual intercourse, in this case with him.
I believe there was. I don't have the docket in front of me. I would have to go back and refer.
So I didn't see anything that would indicate at all that there was any notice given. In fact, to the contrary, that's, I think,
Really?
seems to me why the DA said, well, this is really the first we're getting this particular spin on the evidence during opening statements, which is why now I need to put in this time to intercourse info.
They sent the notice the weekend. They sent a notice the weekend before trial that had his alibi that he comes into town on
I
weekends
mean,
only.
again, alibi and rape shield are two very distinct and different
okay.
things, right? And again, rape shield has a very particular statute, and it has very specific requirements, and there are all sorts of reasons for that, not the least of which is so that people are on notice as to this particular fact, if you will, that a defendant seeks to put before a jury, right?
Let me go back to this. Anyway, as I was saying, if the criminologist is allowed to recite her expert experience in this area as being relevant to the case,
Is that in any way meaning no? That's a no, that there was no
I do not-
233-21B
I do not
motion
believe so.
motion filed, because I didn't see it in the
I do not recall
motions.
seeing one, no.
All right.
All right.
Okay. Thank you. And so the judge, who is sitting here again with a jury in the box, day 5 into trial or so, is then asked to respond to this issue about whether jurors can hear about time to intercourse.
Yes, about
is
time
right?
since intercourse.
Okay. And then the judge looks at Rice, which says again that, and I'm paraphrasing, but this isn't really anything new, and well, I should say it says, because the witness was generally qualified to testify about the presence of sperm cells, that was in Rice, the chemist who has, at least as far as I can tell, similar experience to chemist New, it was not an abuse of discretion to permit him to testify about changes that sperm cells undergo over time. How is this situation different, and why and how should that judge have then said, oh, okay, wait a minute, I need to do a Daubert-Lanigan hearing, excuse the jurors, let's give it a couple days, let's weed this out, or a couple weeks, however long it's going to take?
Because in every single one of those cases, it was never actually an issue at trial. What they said in their testimony, that this background testimony on how long it generally takes sperm to lose their tails, was in each of those cases consistent with the Commonwealth's theory and the defense theory, whereas here it is the entire case.
That's not the case in Rice. There were two opinions. The one that was challenged, the testimony was that intact cells can be found up to 16 hours afterwards, and the defense was consensual sex 21 hours before, and so that conflicted. Granted, there was another opinion that was consistent with the defense, but I don't think you can distinguish Rice on that basis.
I mean, I have here that in Commonwealth v. Rice says it was not an abuse of discretion to opine generally on life expectancy where the defendant had claimed prior intercourse at a time that was consistent with that opinion.
Right,
So
but that's only the case with one of the opinions, the Commonwealth's expert opinions. It was not the case with the one that was challenged. So it was at issue. Otherwise, I don't see why it would have been an issue on appeal, or why there would even have been testimony to that effect.
It was brought up as an issue on appeal without ever having been an issue at trial.
No, I mean, why would you offer testimony to that effect if it wasn't an issue as far as the defense of consensual sex? That's the reason it was admitted.
Well, I'm sorry, in Rice?
Yes.
I'm
So,
sorry,
so again, I don't think that's true. Your factual distinction is true with respect to Rice. So accepting that, is there another ground on which you distinguish Rice?
I would have to review Rice. I'd be happy to file a post-argument letter.
Well, if I can help you a bit, it seems to me Rice is distinguishable in the sense that there, the chemist was opining based on a written, published study, and here you're saying...
Right, in this case, the published studies disagreed with her opinion.
Okay.
Can you just say that again? I know it's difficult.
In this case, the published studies disagreed with the criminologist's opinion. The criminologist's opinion was that sperm tails never last past 2 days, whereas the published studies said that they could last past 2 days, but she said those studies don't apply because those were consensual sex, which was supposedly what she was there to determine.
Did she not testify whether the jury chose to accept it or not, that there were studies that were both consistent with what she was saying, which is 48 hours, roughly, and what the defendant was claiming, which is more like 5 to 9 days, that there were studies that say both?
She admitted to the existence of those studies, but she said they were inapplicable because they were not studying rapes.
Did she also, though, in addition to acknowledging the other studies, did she not testify that there were, in fact, studies that say 48 hours?
And none after. She claimed to have seen studies that agreed
Right.
with her. She could not name them at the time.
And then she used her experience ultimately to corroborate or buttress those studies, right?
Yes.
And then moving beyond that, which is, and again, the judge let it in, so we have to take it as it was. The defendant's defense was, I may have had intercourse in a bathroom at a party, I don't know where, I don't know when, and I don't know with whom, and I don't recognize that woman right there who's the victim. That's the essence of what this time to intercourse was supposed to rebut.
Well, we have to keep in mind that this is being tried 4 years after the crime took place, because that's the first
No,
time they
fair
had the
enough.
DNA match. Most people are not going to remember everything that happened to them on any particular weekend 4 years previously.
Right, but which is why it may not be relevant or probative. You can't remember. Flip side is if the victim can't say, I don't know when, I don't know where, and I don't know who, and I don't know what, that's not terribly probative of anything either.
Well, I mean, yeah, it's not, but it also doesn't add up to beyond a reasonable doubt. Let's talk about Morris.
If I can step back a little, I'm sorry to stop you, but could you tell us precisely which opinions of the criminalist
Yes.
are the error here?
So it's the error is her saying that in her extensive experience, she has never seen slides that looked like what the defendant claimed they were. She said her.
Well, she didn't say that, did she?
She said she's never seen slides that looked like that. She said she's never seen slides from 3 days ago that still had tails, and that she'd seen an enormous amount of rape kit slides in her career.
Yeah.
And that's
And-
true.
okay.
So it's the never seeing tails after 3 days, 2 days. That's the problem here.
Well, that's
the key problem.
Especially when combined with the closing argument saying that means he must be lying. The closing argument tied that together in a way that the jury could not have taken it as anything else. There was no limiting instruction. There was
To be
nothing
fair, she
about-
didn't say he must be lying. She just said that
No,
would.
The prosecutor tied that up in the end and said, she said this, and that means that can't be true.
Okay. I mean, there is a slight distinction.
Yeah.
Can I ask you one other on this one, and then we'll maybe get off it, but, and I know it's different between hard and soft science, but say you had a medical issue. Say the question is on an operating under the influence of drugs, that person is under the influence of heroin, and you have an expert who is permitted to testify about all the symptomology of heroin ingestion and intoxication. Excessively sweaty, pupil issues, sluggish movements, which are all grounded in that witness's observations and experience over the course of, say, 12 years and 1,000 folks who are under the influence of heroin. And the judge says, okay, you can get there, but you cannot say, based on my training and experience and observations here, that this person was under the influence of heroin. So that's the one part of the expert testimony that is excluded and not permitted. Is it your position that the prosecutor can then not elicit testimony of what the defendant looked like and tell the jury, well, you heard what folks under the influence of heroin looked like, you know what this guy looked like, therefore you should conclude that he was under the influence of heroin. Anything wrong with that opinion?
Well, I mean, I think it is what you said. It's the difference between hard science and soft science. The jury knows perfectly well that what he's basing this on is having seen lots of people under the influence of heroin, and that he says that he's observing these same behaviors. This is, what she says is that this is never, these studies have been done and that sperm tails don't exist after 2 days, which is.
She says in her experience of 1,000 observations.
Of rape kits, yes.
She's never seen it. And again, whether that is to buttress
Well-
the studies that she said suggest that that is the case.
And the question is whether that's
And then the
actually
jury,
relevant
then
to
the jury has the opposing view from the defense expert, right?
It didn't. That's the problem.
Well, the opposing view being that studies say could be 5 days, could be up to 9 days. They have that, right?
Yeah, that you can't tell from the appearance of the sperm.
And
however it is.
then, why is it not then a question of the weight of the evidence and the weighing of the evidence and
Well,
putting it in the context of the full case and letting a jury say, okay, this is what we believe, this is what we don't believe?
Well, this is where the lack of preparation comes in part. It's this
When you say lack of preparation,
lack of preparation on the part of the
you mean
defense attorney.
you mean the week? Was this that complicated? I mean, he had a week between the time they found out about the time to intercourse and the time the defense expert testified, right?
Yes, is that time to prepare and prep and find an expert on sperm age? And of course, there aren't really very many experts on sperm age because this isn't a science and you can't reproduce it. They don't pass the test of reproducibility and reliability. In fact, it's not a scientific process. So,
Excuse me, when you I'm not meaning to pick on you on this, but when you say there's not a lot of it on there, but the SJC says this is pretty common testimony. And
it's never testimony that this can't
we
be.
note it is not uncommon for a state police chemist to opine on the life expectancy of sperm cells. And the
if they were
judge reading
going to
that says,
say-
oh, okay.
It's not uncommon to opine on it. It is uncommon, in fact, unheard of, for them to say, and this is dispositive in this case. And if it is dispositive in that case, it's not that much of a stretch to say that they have to prove that this is actually going to tell the jury something relevant and meaningful about the decision they're making, as opposed to simply being a confident assertion that it can't be true, which is just based on the same that they use in hair fiber bite and tool mark analyses. It looks like something that I think it should be, therefore it is. These aren't scientific. But let's talk about, I have only a little bit of time left. Let's talk about Morris. In that case, the defendant's fingerprints on one of the masks used in a robbery that his friends were implicated in wasn't enough to prove he was one of the robbers, because he could have left that fingerprint at any time. It's the same here. Like finding the mask inside the victim's house, Craddock's
Except the
sperm.
victim testified she had never had consensual sex at any point with Thomas Craddock. So doesn't that exclude the possibility of the sperm having been deposited at a different time?
She can't know. She said she can't know. She has no memory. She goes out to
But-
clubs. She goes out to house parties. She has no idea what's happened. She doesn't remember it. She
You
doesn't
have
remember
to disbelieve the victim's testimony to find insufficient evidence? All right.
All right,
This
your
is the
time,
best you got.
your time has expired. Okay, thank you, counsel.
Good morning. May it please the court. Erin Knight on behalf of the Commonwealth, asking this court to affirm the defendant's convictions. I'd like to start off by acknowledging the victim in this case who is watching today's proceedings, as well as the trial prosecutor, Tara Birdman. I think what's really at issue here is the fact that the judge, who was the trial judge and the motion judge in this case, and so we give substantial deference, went through this with a fine-tooth comb and decided that the testimony that she literally babysat during trial regarding the time since intercourse, opinion or lack thereof, was proper and within the bounds of what she had ordered. In fact, Erica New never gave an opinion on this case. What she did was explain what she saw and her experience with tails and sperm motility and things of that nature generally. And that's exactly what the trial judge said could come in, and that's exactly what she also allowed defense counsel's expert to do as well.
Why is it not like a backdoor opinion?
I'm sorry?
Why was it not a backdoor opinion? I mean, she didn't give it, but
Sure, and I understand how it could be seen that way, because obviously it's the point they're trying to make, but that's what evidence is. And I think here, what she's trying to do is give them, and Judge Roach actually says on June 20th at page 202 that she believed the jury could benefit from this expert debate, because both experts said to the jury, like, this is all over the place. It could be 9 days, depending on these factors. It could be 48 hours. It could be 24 hours. So the jury were given that information to go to the weight of what they had to determine. The credibility is the first determination that you make with any expert that a jury makes, and then the weight of that evidence that the expert gave. And
It
as
seems
seen,
to me the problem is that the trial prosecutor walks through that back door because the expert says, well, I've never seen tails after 48 hours, after 3 days. But then the prosecutor argues that, and that therefore you can conclude that the semen was deposited at the time she was attacked and raped, which is kind of like having someone say, I've seen a lot of sand, but I've never seen black sand, and saying, well, therefore this black stuff can't be sand, but just because I've never seen it doesn't mean it's rare, it just doesn't mean it doesn't exist.
Sure, but the prosecutor is entitled to argue reasonable inferences from the evidence. They don't have to be necessary and inescapable. They just have to be probable or possible. And here, that's exactly what she was doing. She wasn't saying that it has to be him because of this, but take the whole context of what happened as well. There can be no debate that this woman was brutally beaten and raped.
That's the problem when it comes to hard science. It seems like a reasonable inference, but how do we know that?
Are you talking about the hard science of the tails or the hard science generally of the sperm being
Any hard
present?
science, right? So it seems reasonable to say, because this chemist has never seen this in all the samples she's tested, that therefore this must be true in this case. But how do we know that that's at all reliable?
Well, because I think going back to Rice in the cases cited within Rice, but also this court's or this Commonwealth's general experience, that we allow the state police chemists or
In Rice, the chemist testified based on a published study. So if all Ms. is it New had
Yes.
done is testify about the studies, which is all the defense expert was allowed to do, this might be a different case, but she didn't. She testified about her own experience.
Correct, and I think the differences between the two experts that were presented, she had this type of experience, he did not. But what they were given, the jury were given, were that even Erica New testified that this is mine, but there are others. There are 72s, there are 9 days. She's aware of that. She knows their peer published studies. So it wasn't just she was getting up there and saying this is the be-all,
But she dismisses all of that as not comparable.
Well, to her experience, yes. And what an expert testifies to and what the judge was sitting there trying to make sure was going along the right path was to inform the jury of something that's outside of the layperson's experience. And Erica New's experience is just that. It's testing these kits over and over. It's looking at what she sees and telling them what she sees in her general experience as a police chemist.
But that seems like expertise.
I'm sorry?
That seems like expertise that needs to be
Well, there's no
disclosed
need-
beforehand and...
No, so there's no need for a Dahlberg-Lanigan here because, quite frankly, we knew this was science that's been accepted in generally within the Commonwealth, as you've seen in Rice. And
So you began to say in this, I just want to make sure we don't lose that thread. Your experience is that this sort of, the sperm head and tail evidence and what it means in terms of time is common.
I would say
in
that's
rape
said
trials.
right in Rice, Your Honor, as Your Honor stated earlier, and not just Rice, but it was also seen in Jewett and Scott, and these are cases that came before this case. They are cases that this testimony came out. I would disagree with my sister's position that it didn't touch on generally guilt of the defendant because that's what this evidence is in a rape case. And under the Dahlberg kind of framework, it's outside of the range of needing to have a Dahlberg hearing. And I would point to Commonwealth versus Davis. I would point to the Camblin line of cases, which the Camblin line of cases is the breathalyzer cases. Yes, Your Honor, I know, I saw that. The Davis case is based on GPS and speed coordinates. And those are things that the SJC has said that type of expertise, that type of new technology, that type of new science is what needs to be given a hearing so we can determine the gatekeeper reliability of that before it is presented to the jury. Here, as Judge Roach found, after much back and forth with both parties, after being presented with the evidence that was going to be presented by both sides as to time since intercourse, said, I'm looking back at these cases and it seems this is common, that the SJC has determined that this testimony, time since intercourse, about tails, about how long you can find sperm within a vaginal cavity, That is
Well,
all properly before.
maybe I've got it wrong, but it seems to me that the evidence that comes in consistently is over time sperm loses their tail, and they generally lose it within 24 hours. But it's not impossible for a tail to last
Correct.
long. But it seems like the criminalist here was trying to testify that it's impossible after 43 hours. I've never seen it after 24 hours, and it's treated as being just there couldn't possibly be a sperm tail after 24 hours. And if that's the testimony, isn't that something new, something that would need some vetting before that comes in?
I don't believe so. Just based on my review of Rice and those cases, I think, a lot of the testimony is up to 48 hours, or a lot of the information is up to 48 hours. Just because it's her experience, I don't think that puts it outside of the bounds of being. She testified of how she testified how she conducts these tests, and it's not anything outside of the normal way that these chemists, these serologists conduct these tests. And so it wasn't like she was doing something new to find tails or to not find tails. In fact, she said she found so many tails that she only took a few pictures because she didn't need to take all of the pictures because there were so many. So she testified to how she did it, which I think the how she did it puts her directly in line with how the testimony comes out in these other cases.
It doesn't really answer the ultimate question because the judge has in the final analysis, a gatekeeper role. But the question I asked opposing counsel about rape shield, is this not, if in fact that is what he was saying, is not classic rape shield?
Your Honor,
classic, it is not quasi.
As you were asking the question, I went back and looked at the docket as quickly as I could. I did not see a specific filing. As my sister said, I'm happy to go back and look, but I think if I may go towards the alibi question that seems to be kind of, or the discovery issue that seems to be a kind of a question, what happened, I think, or what Judge Roach ended up doing was saying, look, I'm going to kind of split the baby here. I think this is relevant given the defense at trial. This is relevant, especially since it's consensual sex. The time frame is very important, and not to mention the underwear she had been wearing, which had been ripped off her body, did not contain the defendant's sperm at that time. And I think that is a big deal. That is a big piece of evidence, and I think that given the time since intercourse in defendant's opening, where the defense counsel says DNA can't tell you how long it's been there or something to that effect, it was going to be an issue for the jury. But where Judge Roach determined that the Commonwealth couldn't go as far as the actual opinion as to, in this case, this is what I believe, which the Commonwealth, you cannot, in the Commonwealth, you can't directly touch on the opinion of the defendant's guilt, but you can touch on the things that affect that opinion, right? And I would say that here, she kept out the actual opinion in this case as like a...
Right, the prosecutor gave the opinion.
I'm sorry?
The prosecutor drew that conclusion in closing.
Conclusion, Your Honor, I would argue that...
It's hard to see how this is not a backdoor expert opinion, because otherwise I don't see what the relevance of the testimony is.
Well, I think that in looking at it as a backdoor expert opinion, we're also forgetting the fact that the Commonwealth in closing argument, it is argument, and they are taking the evidence as it was presented to
I understand
prove the
that,
defendant's
but okay,
guilt.
so these 1,000 samples that the chemist tested, were they centrifuge samples or non-centrifuge samples?
I don't know right off the top of my head,
Was
but I
it-
can go
were
back
they
and see if
samples
she said something
involving
along those lines.
Non-consensual sex or consensual sex?
They were out of rape kits, so I would to my understanding, they would
Maybe,
be
right? Maybe
non-consensual.
not. So how is it a reasonable inference from that testimony that the samples in this case must have been deposited at the time of the assault?
It is a reasonable inference because not only with her experience with tails, understanding how long the defendant...
There's no accounting for the conditions, the variables, or anything like that. This is why I'm having trouble, because the jury is not capable of making these findings when it comes to hard science.
The jury were informed of the different the studies that the two experts were asked about, and it was in fact brought out by the defense attorney, I believe on cross, that the 9-day ones were non-consensual, potentially even fertility studies, if I remember that correctly. So the jury did have information that there were variables.
Right. If all we had in this case were studies, that this would be a different case. But you have the Commonwealth's chemist testifying based on her anecdotal experience that intact cells can never be found after 48 hours.
And that's to her, Your Honor, I understand what you're saying, and I think it is a distinction, but I think at the same time, we're under an abuse of discretion standard. We're under a prejudicial error if there is an abuse of discretion. And if you go to that prejudicial error, quite frankly, looking at this case as a whole, there is no doubt that this woman was raped. Looking at the testimony of Nurse McCarty-Reagan, the only thing that this DNA truly proves without question is the fact that it is the defendant who at some point ejaculated within and on this woman. And here what we have is him saying it's 5 days, the Commonwealth saying, well, she was just raped, there's no other DNA present besides this defendant's DNA. So even if this was an abuse of discretion, if you do believe it to be a inappropriate backdoor opinion, which I disagree with, I think at the end of the day there is no prejudice because there was no other DNA found within this woman who was brutally raped and beaten and left for dead.
What about, in contextualizing that though, what about the defendant's version and what would seem to me be a required rejection of the defendant's version if you accept the time to intercourse information? So short version is, why was this not prejudicial?
So going back to if you didn't, or to not accept his version, or to accept his version.
If we find it's error, if we found it was an abuse of discretion, address the prejudice.
Even taking out the time since intercourse, this woman, what is implausible to believe would be the defendant's version of this woman having 5 days of his semen within her and on her, not dripping out of her onto underwear that she was currently wearing before the attack, and we know she was wearing before the attack because they were ripped off of her body. As Erica New testified, there was no, excuse me, I need to look at this word, phosphatase. The phosphatase that was found within the underwear was not found to also to have sperm. She testified that vaginal secretions can also have that phosphatate. And so
How long would sperm last on the outside of someone's underwear?
Out of someone's underwear?
Yeah, how long would that last if you're wearing your underwear inside?
Sure, I don't think that was testified to, but I will say that Nurse McCarty-Reagan said that the sperm can live inside of the vaginal canal for up to 5 days. So up to 5 days, you would probably expect to see some sort of secretions of the semen. And at this juncture, it was found in her anal area. It was found on her thighs. This isn't an instance in which we can common sense say, oh, this woman must not have showered in 5 days or changed her clothes in 5 days. What we're looking at
So your point is if it's secreting out of her vagina, it's in her anal area, it's on her thigh, and it's not on her underwear.
Where would it have come from?
It didn't come from 5 days ago, is the point.
Correct. So I see that my time is up. If there are no further questions. Thank you.
Okay, thank you, counsel. The case is submitted. We will take our mid-morning break and be back in approximately 15 minutes.
All rise.
Colleagues, we're completely ready.
Now, please be seated.
Okay, we're going to call case number 5, which is John Doe number 29663 versus the Sex Offender Registry Board number 2023 P1043.
Thank you. Good morning. May it please the court. My name is Rebecca Rose, and I represent the appellant, Mr. Doe. Your Honors, Mr. Doe's hearing was unfair because the hearing examiner did not allow for a meaningful consideration of his mental health issues when she denied the motion for expert funds.
Counsel, I'm sorry. Would you mind pulling that microphone just a wee bit closer? Maybe it's just me. Thanks.
Okay.
Thanks so much.
Would you like me to repeat my
No, I got you.
statement? Okay.
Nope. Had to really try, though.
And as well, the hearing examiner misapplied and misunderstood several risk factors that I would like to also discuss today. The hearing examiner, Mr. Doe submitted a motion pre-hearing and at the hearing, and renewed it again at the hearing for expert funds. The hearing, and in both times, he proffered evidence of Mr. Doe's mental health condition, his treatment, the hearing examiner read all the submitted records, and she determined without any regulatory guidance that there was no nexus between his mental health issues and his offending behavior. And our argument, my argument, is that that is exactly why the expert is needed. When there's no regulatory guidance, then an expert is needed to make that nexus between the mental health issues and the petitioner's risk of reoffense and degree of dangerousness. Mr. Doe's proffer was not a general motion. It was specific. It had his diagnoses of bipolar disorder, PTSD, depression, and clinical depression, clinical anxiety. There were supporting documents from treating physicians documenting his mental health issues and his long history of mental health issues. And the motion explained that. The motion also noted that there was no regulatory guidance. There's nothing in the regulations that allow for a hearing examiner, him or herself, to consider mental health issues.
Counselor, the regulation says the motion has to explain how that condition is connected to his or her risk of reoffense or level of dangerousness. And I didn't see where the motion did that.
Well, Your Honor, I believe that the case law says that the motion itself does not have to, that needs to be articulate, a precise articulated condition particular to the petitioner, which the regulations do not address. And that is sufficient for asking for funds. And that comes from Doe 234076, which I cite in my
What would an
brief.
expert have opined on? That if he was treated, that would lessen his risk to reoffend in the future? I mean, what exactly would the expert have done?
And that's what the motion does say, that an expert would explain, would opine on his risk and dangerousness after treatment, after mental health treatment. And I believe if you look at, in fact, if you look at his record itself, you see a lot of, there is a clear line when he started treatment and he stopped offending.
But if that's what the expert would have done, how is that relevant to his current classification level? Right, because the hearing examiner can't say, okay, well, I'm going to classify him downward because he might be treated and be less of a risk in the future. He or she has to determine his current risk of reoffense.
Right, and at the time of the hearing, he was being treated. He was taking medication. It looks like from the records, if you read all of them, that there was a time that they were trying to figure out what the appropriate medication was for him. When he committed his latest offense, the 2020 sex offense that's at issue here, he was not being treated. He was not on medication at that time, and I think that. And again, it's a chicken and an egg problem, right? Like how can a layperson make the nexus, read these without any expertise, read these records?
In Doe 58574, Doe cited several scientific publications documenting it. I mean, couldn't you find something out there that suggests a connection?
Well, the hearing counsel did cite, in his motion for funds, did cite an article. I don't believe he submitted the article. He did cite the article in the motion for funds.
So you argue that the examiner acted as an expert instead of a neutral fact finder.
Exactly, right.
So let me ask you this, because it seems to me that part of the role of the examiner in this capacity is to act as a gatekeeper,
Sure.
right? And like any gatekeeper, you have to determine whether evidence reaches a certain threshold. How do you do that without assessing the evidence, or the proffered evidence, I should say, or the issue? I just don't see how
Well,
you
it
do that.
seems to me, and it seems that my brother argued this in the brief as well, that she looked at these documents as proof of his mental health condition and proof that there wasn't a nexus. And in fact, this was a proffer in order to ask for funds for an expert here. I mean, DOE 58574 also says that a hearing examiner is not imbued with expertise if the regulations do not specifically list them. And in fact, this is exactly when both the regulations and our case law say an expert is necessary in a case like this. This was a documented long-term mental health conditions
What do
that
you
had
mean
been
by
untreated.
nexus? I don't understand. I'm still having trouble understanding how the expert testimony would have been relevant. It'd be relevant if the hearing examiner found there was a nexus between his bipolar disorder and an increased risk to reoffend, which was the case in DOE 89230, right? But the hearing examiner didn't find that. And the problem is the motion itself says an expert will be able to assess the risk that he poses once he has been treated for his mental illness. So that, to me, is not relevant to the current determination.
Well, in fact, his current, they're predicting, the SORB hearing examiner is predicting future behavior based on empirical evidence. So, in fact, if in fact, and at the time of the hearing, Mr. Doe had started again on medication and treatment. He had stopped for a while, and he testified that he was finally convinced that it was helpful, that he felt different and it was helpful. And I think that that if you look at his record, all the years that he was actually committing crimes, and we admit it is a long criminal record. There aren't many sex offenses on his record, but all of them look, I mean, if you read all of his records, his complaints and his symptoms were impulsiveness, poor judgment, racing thoughts, avoidance behaviors, difficulty maintaining boundaries, and all of his offending behavior. That describes all the crimes he committed over the years, and then that stopped when he started treatment. When he was convinced that treatment would be helpful and that it would change him. So in order to convince a hearing examiner that going forward, if he is treated and successfully treated, and I don't know the treatments for bipolar disorder, whether it's more than medication, if it could, there's the magnetic resonances and the shock treatment. There's a lot of treatments for mental health issues. But an expert could have testified with the appropriate treatment if these behaviors would have stopped, right? If you could make a better prediction on future behavior based on...
It seems like if this had been in the motion, it probably would have been granted. But none of this is in the motion.
But Your Honor, I mean, if you read the case law, especially the cases I cited, there's only so much a layperson can say, right? That it begs the question. In fact, when the hearing examiner, in the argument during the hearing, when the hearing examiner asked the attorney, what is the nexus? Like, how do you explain that big gap between the first one and the second one? And he said, well, that's exactly what we need an expert to explain, what was going on in his
Right,
head.
but you couldn't come in and say, my client has tonsillitis, so I'd like an expert to say whether that affects his risk of reoffense. So what's the connection to that? Well, we'll see what the expert says once we get a tonsillitis expert. I mean, doesn't there have to be isn't the regulation sensible? You have to make some kind of proffer?
Well, in fact, the 150 pages of his of the evidence of his treatment and his symptoms and his medication was the proffer, in fact, and how it affects his behavior. And I believe if you look at his record, in fact, there is a link between when he was untreated and all the years before he was treated and before he understood that he needed treatment and that it would be helpful to him. He has a long record. And then he started treatment and he stopped offending. And so I think that even the evidence itself, if you look at his criminal record, shows a nexus between his mental health issues and his offending behavior.
Do you think the examiner improperly relied on the testimony in the initial hearing from your client and his wife that there was no change in his mental state?
Yes, I believe. Neither one of them are experts. Mr. Doe testified that he, for years, didn't think it was necessary or appropriate. He didn't believe in mental health treatment and counseling. So asking a layperson again, do you feel different? Do you think you need help? That is not the same as asking an expert, a mental health expert, asking a psychiatrist or a psychologist.
But in terms of saying, well, before we have you, give you funds to go hire an expert, are you experiencing anything, or to the wife, have you seen anything that would suggest any sort of a change or any sort of something that might?
Let me suggest something almost the opposite, which I did think about when I was preparing this argument. Mr. Doe talks about, in almost every single record, every single time he visits his treating clinician, of racing thoughts, of sleeplessness, of nightmares. So, in fact, if that is his constant state, and he may not have had a change, but that doesn't mean he wasn't having all of those symptoms as well. So, in fact, there's a way to infer that in just the opposite way that the hearing examiner inferred it. Because this seems to be an ongoing mental health issue for Mr. Doe in many ways, not just bipolar disorder, but also clinical depression, clinical anxiety, post-traumatic stress disorder. So all of these affect his behavior, and treatment can certainly affect his behavior. And we're suggesting that the case law, that the threshold isn't that high. You don't need to prove it. You need to proffer the evidence for the hearing examiner, especially here when there's no regulation to guide him. And that is the argument, that it was an abuse of discretion to deny funds in this case.
When can your client move for reclassification?
The statute allows for reclassification every 3 years, 3 years from the date of the final decision.
So it'd be next year, right?
However, he's going to have the same, it's going to be the same argument. Guidance from this court of whether or not it's appropriate based on this evidence.
That would be a different factual scenario if, in fact, he's been receiving treatment in the intervening 3 years, right? He's entitled to expert funds in a reclass proceeding, right?
Sure, he is, but he is also indigent, which means that he would still have to ask the board for funds.
Right,
so
but
we'd have the same question.
Well, it would be a different factual scenario, right?
Well, sure, but the issue is whether this hearing was fair, whether the hearing he just had was fair. And it is our argument that it was not fair based on the hearing examiner's decision. With my few minutes left, I would briefly like to talk about the hearing examiner's final conclusion of she gave him a level 2 classification because of his, as she says, his persistent and deviant interest in young girls, his persistent interest in preying upon children. And my argument here is that these two sex offenses were qualitatively different. His first sex offense in 1997, he was a teenager, he had sex with his girlfriend. And even the hearing examiner and the regulations don't consider that to be as serious and risky behavior. 23 years later, he was soliciting online sex, sending pictures online, again to somebody he thought was an adult. Turns out, then he was convinced that this was a 14-year-old, and he went ahead and kept exchanging. But
that's you agree that's not relevant to our analysis. The fact that it was an undercover who was not in fact 14 in terms of assessing his predilections.
I do make the argument that it was arbitrary and capricious to consider the touching, discussing his interest in his discussing the sexual acts he was going to do, to treat them as if they actually happened. And I do make that argument in my brief. But I'm suggesting that the final analysis, the discussion at the end of the hearing, hearing examiner's decision, when she calls him a persistent, he has persistent deviant interest in young girls. And again, the facts just don't support that. That's a stretch based on the facts, based on the qualitatively different kinds of crimes these were, how far apart they were, what it doesn't show a considered, a consideration of the actual facts and circumstances in Mr. Doe's case. That if he were a persistent, deviant, interest in young girls, it would have shown up all over his record and not just this last time. And I just want to suggest that this was not the hearing examiner didn't make the most particularized decision in this case.
Okay. Thank you, counsel.
We would ask that you vacate the Sorb's decision and remand for a new hearing.
Thank you, counsel.
If it pleases the court, David Chennai for the board. I appreciate you taking this case early because I'm going to go next door to another case, so which actually has a similar argument in the sense that it's involving an expert or denial of expert funds. This case is interesting because the hearing examiner did two things that surprised me. The first is the hearing examiner didn't just rule prior to the hearing and say, I deny the motion and therefore I'm not going to revisit it. The hearing examiner spent the hearing trying to elicit information from the plaintiff and plaintiff's counsel that would make the connection, the nexus between his condition and his request for expert funds. Hearing examiner asked, did you raise an insanity defense or an issue at the trial when you were arrested and brought to court? Also asked specifically of both of the girlfriend or the wife, was there a change in his demeanor during that time, a change in his mental status? And she said no. The hearing examiner was giving the plaintiff every opportunity to make that nexus during the hearing, because if he had made the nexus, the hearing examiner would have given a second day of hearing and allowed the expert. It never happened. And the hearing examiner went out of her way to give the opportunity for counsel or his client to make that nexus. And I think you're hitting the issue right on the head is under Doe 89230 and the regulation 1.164, which emanated from that decision, the burden is on the individual to show that there is a nexus. And again, in this case, the hearing examiner gave that person or this offender multiple chances to make that nexus. So I think that the hearing examiner weighed it out carefully and I think made the right decision in this matter because, again, the offender and his attorney didn't actually make the required proffer to get expert funds under these circumstances.
Attorney Shania, your response to the argument that the finding that there was persistent deviant interest in young girls when the first one is at least qualitatively different from the later one.
Yeah, it is, and it is qualitatively different, but it was still a 14-year-old girl, and in this case, he solicited online what he believed to be a 14-year-old girl and told the girl all of the things he wanted to do to her. And I think it was pretty specific and very graphic, the things he said.
I don't think we...
And then he shows up at the hotel.
With the second one. But the first one, what is he, 17 at the time? Or
right.
And she's 14?
I think if you look at it and say, okay, that's the only time that he involved a teenager, it's the fact that he did it years later. I think the second case is probative on that. The girl checks in to his chat room. He, as the administrator... he, as the administrator, basically, if you read the text, he not only takes her under his wing, kind of starts grooming her, and then discusses everything he would like to do with her, gets her to say that she's going to be at a hotel, her mother's really busy, and he appears at the hotel. I think that that's predatory behavior. You look under factor 36, it is the highest level of danger posed by an online offender.
I agree with, again, I'm not quarreling with the second offense, but the first offense, the one when he was 17, the hearing examiner applied factor 4. The basis of factor 4, I take it, is that if you have an early onset of deviant behavior, that's predictive of future deviant behavior. How is a 17-year-old engaging in consensual sex with a 13-year-old deviant behavior?
I think it's the age issue. A 13-year-old girl and a 17-year-old boy. It's not like he was 17 and was having sex with a 17-year-old or a 16-year-old. He was having sex with a 13-year-old. And there's a predatory situation there in the sense that being 13, you would think emotionally and worldly-wise, the girl is susceptible to manipulation. And I think that's really what it comes down to. Again, it wasn't peer aged. There was a significant difference in their ages, and the girl was barely a teenager.
Did the hearing examiner make those kinds of findings? It seems like she or he just rotely applied factor 4 without considering the underpinning of the regulation.
I think there's case law that says that a hearing examiner, when you make application of factors, they don't have to list every reason why they do it. I personally wish I could make the findings of fact, but I don't get to do that. I have to accept what I'm given. And I think I try my best to argue around these issues.
They don't have to explain everything, but I like things to make sense, and to me, it doesn't make that much sense to me to apply factor 4.
You know, again, it's your prerogative. If you find that there was a little overboard to apply factor 4, then you have to decide whether or not it materially affected, I think Justice Ditkoff knows this language, whether it probably affected the classification decision. The board's position is, I think the case is pretty much overwhelming. I think the most recent incident is really a red flag, and I don't think you can get around that. I think that was my second surprise by this hearing examiner, that she made him a level 2. I think he could have easily been a level 3. I think she fairly looked at the evidence, looked at the mitigating factors, tried to factor in the mental health issue and the fact that he is presently getting treatment, and tried to put that all together and came out with a 2. I could easily defend, I believe, a level 3 on this case. And again, I'm not the finder of fact, but looking at the evidence as a whole, I don't think factor 4 materially affected the decision in that level. I think that if she relied on factor 4 to make him a 3, I think that that would have been different. But I don't see, after the most recent incident, him becoming a level 1. It's just, the behavior is too predatory. It really goes to the heart of what the board is trying to protect, which is young people from being manipulated and forced into sexual situations, which this could have easily happened if this was an actual 14-year-old. And I don't think you can get around that and say because he applied factor 4 improperly, that it would have resulted in a level 1. I just don't see that in this case. And that's essentially the board's position on that issue. And again, I think I've hit these issues as hard as I can in my brief, and unless there's specific questions, I'd be more than happy to rest on my brief.
I think we're all set, counsel. Thank you very much. Thank you both. The case is submitted.
Thank you.
Okay, we will go to case number 4, which is Fontana versus City of Boston, number 2023 P 1300.
Good morning. May it please the court, my name is Neil Janowitz and I represent the city of Boston in this matter. In this case, as required by the CHOPS contract, the city paid the plaintiffs cash and credited them comp time each year when they redeemed 10 vacation days. The plaintiffs brought this action seeking cash at retirement for their accrued comp time, effectively a second payment for that vacation time they redeemed each year, which is not required by the contract, plus treble damages and attorney's fees. Superior Court entered judgment on liability in favor of the plaintiffs on the Wage Act and the breach of contract count. Based on the plain language of the contract, settled Wage Act case law, and established principles of contract interpretation, the Superior Court judgment on liability should be reversed for two reasons. First, the Wage Act claim fails as a matter of law because the CHOPS comp time is contingent compensation. It's not an earned wage. Based on the record, the comp time is the credit of comp time is triggered by the annual vacation redemption benefit, not by performing work. Under the SJC cases, the appeals court cases, a First Circuit case, such contingent compensation is not an earned wage under the Wage Act. Second, the plaintiff's contract claim fails as a matter of law because the contract is unambiguous. Silence doesn't create the ambiguity. The court must interpret it according to the plain language, and there is no express obligation in the contract to buy back comp time. Now, to first address the procedural issue, the court entered judgment on liability, but it did not include damages. As such, it is not a final judgment, and technically the appeal is premature. Nevertheless, the city asks the appeals court to exercise its discretion to decide the fully briefed issues. There's a case law where that has happened, where the appellate courts have exercised their jurisdiction, especially when to do so would be the interest of judicial economy. The Providence and Worcester Railroad case I cited in my footnote of my brief, the SJC did that. There was no final appealable decision.
Is that the citing board case?
Yes, it is.
And they went ahead and addressed the merits because they found there was a public interest in prompt resolution of the issues and that the answer was reasonably clear.
Correct.
So you're probably going to say the answer is reasonably clear, but what about the second requirement?
In other cases, the appeals court has exercised its discretion. That was SJC. In Lombardi, 68 Mass App Court 407.
I'm sorry, 68 Mass App Court
407.
407.
In that case, it was a family matter case. Alimony issue was still had not been decided. That claim still needed to be decided below. There was no 54B motion. The appeals court recognized the appeal was premature, and the appeals court fully addressed the fully briefed issues because it was in the additional interest of judicial economy. The court noted that there was nothing to be gained by sending the parties back, dismissing and sending the parties back to come back and do the same appeal all over again when it had already been fully briefed. In Creatini versus McHugh, 99 Mass App Court 126, 2021, the appeals court again.
I'm sorry, again, the citation. The citation.
99 Mass App Court 126. The appeals court exercised its discretion to, again, decide a fully briefed appeal. In that case, similar to this case, there were two notices of appeal, technically premature. They didn't go into the details of why they were premature, but they said they were both premature. And the court decided the issues of liability because to do so.
I mean, it couldn't be that just because an appeal is fully briefed that we would decide the merits. That couldn't be, right? Because it would mean that any improper appeal, interlocutory appeal, as long as there's no motion to dismiss and it's not dismissed, we decide. I mean, that can't be the rule.
In those cases, the court, especially in Lombardi, the court recognized that it had no obligation to decide so, but it was exercising its discretion to do so. If they decided the issues before them, and because if they had sent it back, it was coming right back. I understand it would create a rule that would be against the rules of finality of a judgment, but it is, the appeals court in Lombardi expressly recognized that this was an exercise of discretion and not something that the appeals court was setting a precedent for it to do in all cases.
Do you and your friend agree what the damages are?
There is one issue with respect to Mr. Fontana. If you look at the carryover comp time, he's claiming 532 hours. The comp time in the carryover request, it was for 490 hours that were earned as a CHOP. The letter for the carryover expressly states that their 42 hours are the origin is unknown. So there would be a dispute over those 42 hours, whether those were part of this CHOPS contract. But the court, as back to Justice Shin, your point, the answer is reasonably clear here, because based on the settled Wage Act case law and ordinary principles of contract interpretation, the court should reverse the issues of liability.
So the way this works is you get paid out for the vacation time you haven't used, and it reforms as compensatory time up to a certain number of hours, right? Days? That's how it works?
Each year, in a way, yes, in a way. Each year, if the CHOPS had vacation time left over after 1 year of service,
Yeah.
they could turn it into cash. They got paid cash right then and there and comp time. So they effectively got paid a 2-week bonus while still being able to take their time.
Right, so why isn't that comp time just vacation time by another name?
It is not the same as their vacation time because there's a cap on vacation time. There's a cap.
But there's always, not always, but every job I've had, there was a cap on vacation time. And I got capped every time.
This comp time is not earned for performing work. This comp time is received as a benefit for exchange as a benefit under their contract, an extra benefit. But
if it's literally your vacation time that you've earned and haven't used, then why isn't it vacation time? I don't know why paying out 2 weeks of it magically makes it not vacation time just because you call it compensatory time. It seems to act exactly like vacation time. You earn it the same way. It's actually literally calculated the same way, and you can use it the same way, right?
It's no longer vacation time because a vacation day has two components. A vacation day, you can either take the time off and be paid for that and not have to go to work that day, or you bank it and you carry it over and you get paid at the end. You don't get both. By exchanging your vacation time, you're giving up your vacation day, which is a different type of day.
But are you giving away your vacation time when you get the exact same thing? It just is relabeled compensatory time? It sounds like it's exactly vacation time.
But then there would be no need to exchange your vacation time to receive it, because the contract could have just said you get 2 weeks extra pay. Then the contract doesn't say that.
But the question is that what the contract says? It seems to be how it works. At the end of the year, if you didn't use your vacation, you get paid 10 extra days and you still have the vacation. It's subject to how much you can carry over. I don't understand why that's not what the contract says.
Because you actually have to redeem it. You might not want to redeem it. One, you might not have vacation time. Two, you might choose not to redeem it because the vacation, you could have a bank up to 10 weeks, I believe. So you may want to bring that bank up. You may choose not to retire it. And so therefore, it's different. If the contract, it goes to the ordinary principles of contract interpretation. If the intent was to just give an extra 2 weeks salary, the contract could have said that. The contract doesn't say that. The contract says at the end of the year, you can choose to redeem up to 10 days of vacation time and in exchange receive cash and comp time. The comp time is different. It's no longer vacation time as a legal matter. It's something different. It has a different name. To spin it to the Wage Act, the significant point for the Wage Act under the case law is why you get it. So even if it has to be paid, why you get it is significant. If the payment is triggered upon meeting criteria or meeting a triggering event, then It is contingent compensation and not an earned wage. An earned wage is paid in exchange for doing work, for completing a service. The First Circuit highlighted this in the Sullivan case. And that was a severance pay case, and the severance was triggered payment was triggered by meeting the criteria of being terminated without cause, or if the employee terminated for good reason. And
Can I just stop you for a moment? Is there anything in the contract, I didn't see it, but that speaks specifically to the retroactive approval of carryover comp time?
No, and I would say the way the contract is written, the approval has to be every year, because it isn't.
Why?
As laid out in my brief, it is in the annual redemption section, the annual vacation redemption section. The first sentence, all three sentences apply each year. The first sentence applies each year. You get to redeem your vacation time each year. The second sentence applies each year because you exchange your vacation time for your comp time each year. Therefore, the third sentence must be applied each year.
So the same two people, otherwise exactly equally situated, one of whom gets the annual approval and the other whom just isn't that good with his paperwork, and 3 years later says, hey, can you just retro all my approval? One guy gets it and the other guy doesn't? Or
under the terms of the
person, I should
contract,
say.
that's the way it should work, yes. Under the terms of the contract, that's the way it should work. There's nothing that says you can approve it retroactively. It would arguably be a change to the contract, which a commissioner can't do on his own. The mayor and the CFO signed it. They would also have to sign off on that. But back to the key point of the Wage Act, distinguishing between contingent compensation and an earned wage. Back to Sullivan, footnote 2. The court expressly pointed out that the difference between contingent compensation and an earned wage is what triggers the requirement to make payment. And it's the difference between meeting criteria, which is what the comp time is in this case. You need to meet criteria in order to receive it, as opposed to actually doing work.
I thought all the contingencies had already happened before this. It wasn't contingent anymore at the time of the retirement, I guess.
The fact that the contingencies are met is irrelevant under the case law.
Well, why is it irrelevant? It's one thing to say, we don't know what the severance, what will happen, how you're going to get terminated, but, you have to do a certain amount of work to earn vacation time. But once you've earned it, no one would say, oh, well, that was contingent on you doing the work, or contingent on you not taking vacation. Otherwise, you wouldn't have vacation time. Well, once it becomes firm, why is it still contingent?
Because the case law says so. In Brzezinski, the Brzezinski court pointed out that the person made the argument that that definitely determined contingent compensation should be paid. Under the Wage Act, that only applies to commissions, and Brzezinski wouldn't allow it to go to all types of contingent compensation. The Mui court also expressly differentiated between commissions and other types of contingent compensation. The Mui court, the SJC and Mui said, other than commissions, the SJC has refused to extend the definition of earned wage to any other type of contingent compensation. So if it's not commissions and there's contingencies, as the way the case law is played out, it's not an earned wage. In Mui, the conditions were met. They went to the two conditions were work for 2 years and don't get fired. They went to arbitration to determine whether or not they were fired. The arbitrator determined he wasn't fired. He had retired, so he met the contingency, and they made the payment. But it was a year late. The SJC said still not a wage. I mean, they didn't expressly address the contingencies being met, but the facts before them were that the contingencies were met.
As it relates to judicial economy, just explain again why it's more judicially economical for us to take appeals in this manner.
Well, first and foremost, the answer is reasonably clear. Settled case law. Once you decide for the defendant, the damages issue becomes moot. And even if you didn't decide for the city on both cases, if you decide under the Wage Act claim, the damages issue is reduced because there's no attorney's fees on the table any longer, and it would just be what the comp time
It kind of
was.
presumes you win.
Yes,
Okay.
On the breach of contract claim,
yes.
are you saying that it should be decided as a question of law? In other words, let's say we agree with the plaintiffs that the contract is ambiguous. You're not arguing that the case should be remanded for factual development, correct?
In that case, that's where the, sorry, my time is up, but to answer your
yeah.
question, that's where the incorrect application of law, it should be remanded because the court, to enter judgment for the plaintiff, viewed the facts in light of the plaintiff's favor. If they viewed them in the city's favor, she might have found it an issue of fact.
But there's a footnote in the judge's decision that seems to suggest the parties agreed this can be decided on the record as it currently stands. You're not saying this has to go to trial on the breach of contract claim, right?
No, trial wouldn't be necessary.
Okay, so you agree that it should be decided on summary judgment on this record?
Correct.
Okay, thank you. Okay, thank you, counsel.
Good morning, Your Honors. Paul Kevin Flavin, representing retired Boston firefighters Gerard Fontana and John Walsh. Thank you. The first issue, I think, regarding the contract is whether or not there is an ambiguity. I think the record is clear. The city of Boston itself, when both firefighter Walsh and Fontana retired and they submitted their retirement buyout form and had the compensation on it, the city then engaged in a question of, well, wait a minute, do they get paid out at retirement? And they
You can't go to extrinsic evidence to show ambiguity. The ambiguity has to be on the contract, right?
Correct. But the ambiguity started immediately by the city of Boston questioning the CFO, questioning the head of...
But that's all extrinsic. My understanding is that for it to be ambiguous, we have to be able to find the ambiguity just from reading the contract, not from what the parties did.
The contract, it doesn't say what happens to the compensatory time on retirement, so it's ambiguous. So the city began to question, what have we done in the past? They immediately, before this even became a legal issue, looked into what have we done in the past. As a matter of fact, Emma Handy wrote in an email that whatever we did in the past wouldn't be changed by the contract. And they have the contract in front of them. So if it was unambiguous, there wouldn't be any reason to question what have we done in the past. The issue came up and they were asking each other, are they allowed to buy back the comp time? Here's the contract. Ms. Handy provides a copy, and they investigate past practice, and lo and behold, every comp prior who had comp time was paid upon their retirement. And the contract was drawn up by the city of Boston, so any ambiguity should be interpreted against the city of Boston, particularly when their prior actions confirm that compensatory time is bought out at retirement. The record was also crystal clear from the commissioner to the CFO of the city of Boston that this comp time is in lieu or representative of the fact that these firefighters are on call when the commissioner is not available.
It's a hard argument to get ambiguity there because just a normal contract would say, here's the sick time you get, and it wouldn't say anything about getting paid out for sick time when you quit. And no one would think, oh, it's ambiguous, maybe you get paid out for sick time. The default would be you don't get paid out for any sick time when you quit. That's what normally happens. And just the mere fact it doesn't say whether or not something gets paid out, doesn't that suggest that it doesn't get paid out?
Well, no. The also relates to, my next comment also relates to whether or not you can retroactively approve the carryover of the time. The software for the city of Boston, the PeopleSoft is the name of the software that tracks this compensatory time, sick time, vacation time, all the benefits that you acquire and accrue during the time that you act as a firefighter. Each year, it increases. The city of Boston's own software, when these gentlemen firefighters retired, had 490 hours of comp time for Mr. Fontana and 420 hours for Mr. Walsh. By the way, we don't disagree with the city on Mr. Fontana's hours. It's 490. Again, the damages won't be an issue once the decision by this court is rendered. We agree with the hours that are reflected in the City of Boston's payroll software, PeopleSoft. And that software, if the comp time wasn't authorized to be carried over, then it would be gone the next year. If I use my vacation time, it doesn't appear the next year. This comp time, the City of Boston accrued it each year, accumulating the 70 hours each year. So I think it was tacitly authorized by the very fact that it's carried over with the software, showing the amount of comp time increasing each year.
This contract says written approval of the fire commissioner, not implicit approval by whoever's running the computer system.
I agree with you, Your Honor. That's why I think that there was a administrative validation at the end of 2019 when these firefighters were about to retire. They got the permission of the commissioner to carry it over. Again, reflective of the City of Boston software, which had accrued it each year. If you didn't use
Well, wait, so I don't, that I'm having trouble following, because if, I thought your position was that the commissioner, by written approval, could retroactively approve it for multiple years, but you're saying that it kept accruing without his written approval every year. Is that what you're saying?
No, I'm saying, in fact, the city kept accruing these hours each year.
Before the written approval happened?
Correct. And then...
Wasn't that wrong? I mean, that's not what the contract says, right?
I'm not suggesting that it's wrong. I'm suggesting...
But I'm suggesting it's wrong, because without written approval, you can't carry over more than 10 days.
But they in fact get the written approval at the end of 2019, when they were going to retire.
Okay, but are you saying that from like 2016 to 2017, they carry over more than 10 days of compensatory time in the computer system?
I'm not saying they carry. I'm saying the City of Boston, in their software, shows these compensatory time accruing.
But that's wrong, right? Because without written approval, you can't go more than 10 days.
And I don't think it's wrong. I think...
How could it be right? This says you can't go more than 10 days without written approval of the commissioner.
I would have no idea. The City of Boston did it. They're the ones that accrued the time. The commissioner approved the carryover retroactively for those number of years prior to the firefighters retiring, which is per the contract. I think that's why the commissioner did that, because it was necessary for the commissioner to approve the carryover.
To fix the computer error?
I'm sorry?
Are you suggesting that the written approval was to fix the computer error?
No. I'm suggesting that they...
Retroactively make it work?
The written approval by the commissioner is necessary. What I'm saying is, I would be in a worse position if each year the City of Boston in their software zeroed it out.
I think you'd be in a much better position, because that would be consistent with the commissioner retroactively giving you things that he didn't have to do but decided to do. If the computer system was going beyond what the contract said every year, doesn't that make the computer system completely unreliable for our purposes?
Well, I don't think it makes it unreliable. I think the intent, both by the city and the fire department, was that these firefighters would be compensated for working. They couldn't get overtime because it's a non-union position, but they in fact covered for the commissioner for over 12,000 hours totally for both of their careers, as evidenced by checking in with the alarm. They have to check in when they go on call. So there's record of the hours that they're on call to respond to fires when the commissioner is not available. And both the commissioner and the CFO of the City of Boston said this compensatory time is recognition that they put in this on-call time over and above their Monday through Friday regular hours. And the fact that the city tracks it each year and increases it, I think demonstrates that there's an intention that there's going to be a possibility of this being paid out at retirement as long as the commissioner authorizes the rollover, which he did. To the extent that it's a wage, again, we're relying on the Plourde case where a Lowell Lowell police officer could choose when he worked overtime to receive payment or comp time. Officer Plourde chose to receive comp time. When he went to retire, the city refused to pay him the comp time. It was found to be a wage. It's a similar circumstance here. It's the same circumstance. Everyone acknowledges this is to be compensation. The very name of it, and the reason, Justice Ditkoff, you question vacation time. No, it's not vacation time. It's compensatory time. It's compensation. Compensation for what? The record was clear. For being on call for the commissioner when he's unavailable.
Yeah, I'm not sure that helps you as much as you think, because if someone decides, hey, we're not going to give you overtime, you're going to be salaried, and in exchange we're going to give you a higher salary, that doesn't make it overtime. It's just the reason why the contract is structured that way. Where in Plow, which wasn't even a case about the Wage Act, was about whether the Lawrence Act superseded the Wage Act, these times were actually directly connected to overtime. This competence time is directly time for overtime shifts, where this doesn't seem to be.
Well, it isn't, Your Honor, because the contract specifically says they're not entitled to overtime because these are non-union positions. It's the only two non-union positions a firefighter holds in the Boston Fire Department, or can hold in the Boston Fire Department. And it wasn't contingent.
Where in Plow, it was the CBA, the collective bargaining agreement, specifically called the additional shifts overtime.
Yes.
As opposed to a contract here that specifically says no overtime.
This contract clearly states there's no overtime, but it's obviously acknowledged in testimony by the commissioner and the CFO for the city of Boston that this is a benefit given to attract firefighters who are no longer going to be, who are used to being able to work overtime. They're now no longer going to work overtime. They need to attract capable individuals.
I don't understand why the Wage Act makes anything that's designed to attract people wages.
Well,
why does the motivation for the payment affect whether it's a wage under the Wage Act?
Because the motivation, Your Honor, is they're working. They're on call to be called to fires that are over 3 alarms in the city of Boston.
So why wouldn't that apply to any salaried employee who obviously doesn't get, who's expected to work more than 40 hours, that anything in their contract would have to be considered wages, even their sick time, for instance, because that's how they attracted that person?
Well, no, I would disagree. With sick time, I have to be sick.
But what if we give you lots of sick time to compensate for the fact you're salaried?
I'm sorry, Your Honor?
What if we give you lots of sick time? You know, no overtime, you're salaried, but we're going to give you as much sick time as you want, unlimited sick time.
All right, but once again,
Up to 180 days a year. Why wouldn't that suddenly become a wage?
Well, I'd have to be sick. No matter how many days it was, the theory behind sick time is I have to be ill in order to invoke it.
And you get to cash it out when you retire.
You're saying if that
Yeah,
would
the
be
contract. No salary, but we'll give you 3 months of sick time a year, and you can cash it out when you retire. Does that become a wage under the Wage Act?
Well, once again, no, because I think that to use it, you have to be sick.
Well, I just said you don't have to use it. You can cash it out at the end.
I think that would bring it closer to being a wage, yes, if I can cash it out.
All right.
And once again, the reason it's called a different name, not vacation, compensatory time, is for the simple fact that it's compensation for work performed above and beyond their 35-hour work week, Monday through Friday.
Okay, thank you, counsel.
Thank you.
Thank you both. The case is submitted. Okay, the last case on our list is the Department of Children and Families versus Mother and Others, number 2024P118. This case is impounded, so I'm sure as the attorneys know, please avoid using names to identify the parties and other people in the case. I understand you're splitting your time. 7.5 and 7.5? Okay.
Good afternoon. May it please the court, I'm Eric Viel on behalf of the appellant mother. I'd like to let the court know that the mother is here today in the courtroom. I also need to begin today with an apology to counsel for the department. I filed on behalf of the child a motion to correct and a motion to stay. I inadvertently did not serve Attorney Price. I served Monica Murphy from the department. As I understand it, I've spoke to Attorney Price, and he does not intend to rely on the issue of service substantively. I would suggest to the court, by way of cure, that the department should obviously have opportunity to respond in writing to both those motions. On the merits of...
Could I ask you about the motion to stay? So normally we see these earlier in the appeal proceeding. So what benefit is it to stay the appeal now, given that you're here for argument?
The benefit to the mother is that the relief the mother is seeking right now is the opportunity to go back to the juvenile court, to have this appeal stayed, and go back and file. And I recognize and acknowledge, I gave you a draft affidavit, so you don't have a fully formed 60B motion in front of you.
But she can file that motion regardless of what happens in the appeal. Once the appeal is either stayed or resolved, she can still file the motion.
My understanding, Your Honor, and I may be mistaken, is that if this court were to affirm the termination decree, mom would be without standing to have any further involvement with permanency.
Well, she can still challenge the underlying judgment through a post-trial motion, right? Post-judgment motion.
Then I may be mistaken, Your Honor, that there would be still mother's preference to have judgment in this case deferred, stay the matter, allow her to take the matter back to the trial judge, and show extraordinary circumstances warranting relief.
That motion hasn't yet been filed?
I'm sorry?
That motion has not yet been filed?
No, it is not.
How close is it to ready?
In the motion I asked for 30 days. I believe the motion, working with trial counsel, could be filed within that time. I don't know that it would be adjudicated and heard within that time.
No, but just how close are you to actually being able to file it?
We're working on it, and within 30 days, we would have it filed. There's an alternative remedy in that the child could seek review and redetermination, irrespective of what happens with mother's rights. The difficulty with that is, number one, mother very strongly wishes to be a party and to have standing and due process and counsel at a matter seeking post-judgment relief or review and redetermination. And so that's mother's first preference. I believe, either way, I believe this matter is going to end up back in front of the juvenile court, whether it's allowed a motion for post-judgment relief by this court, or whether it's review and determination by the child, as the child is aligned with the mother in this case, wishes to return to mother. If there are no further questions on the issue of the stay, on the merits of the appeal, primarily mother is arguing that the evidence of her unfitness by the time of trial lacked vitality. There was a lot of evidence regarding verbal arguments between the mother and her ex-husband. Mother acknowledged that in her testimony. She acknowledged that it wasn't healthy for the kids and that she had let the kids down. And she understood that the kids were frustrated. with her. And she also testified that she had, through services, learned how to better communicate, and so that those issues of the arguments that were disruptive were no longer an issue by time of trial. And DCF did not have any evidence to rebut that testimony. And while the trial judge certainly can make credibility determinations, and did, and the trial judge could say, well, I find mom not to be credible on this issue, that does not create the evidence that there were ongoing domestic violence between the ex-husband and the mother.
I have some questions about your hearsay argument. I saw in your motion to eliminate where you asked for the 51Bs to be admitted only for primary fact, but I didn't see anywhere where your predecessor asked for the same thing for the foster care reviews or objected on hearsay grounds to them in any way. Am I missing it?
Your Honor, the motion to eliminate did apply to the DCF created reports and also to totem pole hearsay. I don't recall the foster care review reports being specifically singled out. However, in response to Mother's motion, the court did limit admission of the documentary evidence to the standard case law. It was offered by the department under those limits, and that's how it was admitted. And so I submit that the issue was preserved.
Well, the motion says Exhibits 4 through 54, 51As, 51Bs, and record reviews and conclusions contained in 51As and Bs, but I didn't see foster care reviews or any of the exhibit numbers beyond that. Is it somewhere else? And that was all acknowledged, that it would be ruled.
That's the motion that was filed, Your Honor. And the department has argued that the issue wasn't preserved. And I would argue that those were limitations expressly placed on the evidence by the department in offering it and the judge in allowing it.
And in a similar vein, you argue here that there's luck doesn't really apply when the declarant is your child. And I didn't see anywhere where that was raised below. Is there somewhere that argument was made?
Not specifically, Your Honor. The evidence was offered admitted subject to standard case law, I think was the language. Luke has been around since before trial. And my argument is that standard case law would include Luke and its restrictions on hearsay and multi-level hearsay in DCF created documents.
Okay.
With respect to best interests, I will defer to my sister who represents the child. I would say in summary, and I see I'm running out of time, there were 5 children named in the petition. Mother had her first child when she was 17. She mothered these children for many, many years before they were removed in 2017. The problems with fitness were the ex-husband and housing, and Mother has divorced the ex-husband and has stated in her affidavit housing is no longer an issue. I would ask the court to please allow Mother leave to file a 60B motion seeking post-judgment relief or vacating the termination decree and remanding for further proceedings. Thank you.
Thank you, counsel.
Good afternoon. May it please the court, I'm Madeline Blanchette, and I'm here to argue on behalf of the child. Here, a 14-year-old boy has been consigned to live out his childhood in substitute care, deprived of the mother and the siblings whom he loves. Terminating Mother's rights was not in the child's best interest, and I'm really asking this court to see the child, to really focus on the child and the child's best interest. There were other children in this case. There were 214 findings made in this case, and there were only 12 findings that even have my client's name in them. So what I'm saying here is that my client just got swept away the zeal to find mother unfit. And adoption of Nancy is clear that it's not enough just to find current unfitness. The child has to experience some gain. And in this case, all the child has done is lost. I want to just really focus this court, please, on the grim reality of this child's circumstances, which were not noted by the trial court. So I noticed that my brother on page 40, I think it's on page 45 of his brief, he cites to findings 208 through 210, saying that the child, which is correct, has a problem with aggressiveness and sexual acting out. Those findings do not say that. There are no findings that say that the child has a history of aggressiveness or acting out sexually. So that is also went over to the 210 plan, which was also silent on those issues. The 210 plan acknowledged that he had some special needs. The 210 plan, though, was silent on so many things that were important. In fact, the 210 plan said in general that my client has good skills at self-regulation. He's polite and respectful. I mean, this is just, to call this a whitewashing of the situation is an understatement. I want to also mention in my brother's brief from DCF that he cites adoption of Sarissa, saying that that the court did not need to have a 210 plan that had precise findings on what the adoption plan would be. That case is distinguished from the case here. First of all, in Sarissa, the 210 plan outlined in detail the special needs of the child. As I just said, that's not the case here.
Extensive detail.
Yeah, pardon?
Extensive detail.
Thank you, Your Honor. Yes, extensive detail. Also, they said that the child was so dysregulated at that time that that child couldn't even express a position. Here, the child is a stalwart appellant. He's 14, he can block his own adoption, he could have blocked his own adoption at trial. The other major thing in Sarissa that's different is the child there, DCF conceded they weren't even ready to be adopted. So, and one of the reasons that they allowed the plan not to be super clear is because they didn't want to bump out any of the kin that had come forward who might be potential adopters. I mean, this plan is saying that my client is good to go. The only problem is nobody wants him. And that is not factored in here. At trial, the adoption social worker, she conceded, he's 12 years old, the chances are, slimmer for the young kids that he'll be adopted. She said, you know what, it's true, when people see the special needs, that's going to give them pause. These things are just not addressed by the judge at all. I mean, we're talking about a 14-year-old boy. I saw him yesterday, he has a mustache. This is a young man. This is not like a tiny child who is going to be picked off of a website and adopted by people. Yes.
Sorry. Understanding how busy the juvenile court is, if we let you go back on the 60B, what's your best sense as to the turnaround time for that? Not just the filing of it, by the time it's actually resolved on some level. Are we talking
Your
months,
Honor,
a year? Are we talking
that's
realistically?
that's a tough
What
question.
makes more sense?
Pardon, say it again?
When we're weighing what makes more sense here.
The good news here is that there's only 3 parties left, whereas before there was 6 or 7 parties. So in terms of scheduling the hearings and stuff, I think that would be much quicker. I mean, I would say that would go to the top of my priority list, absolutely.
usually the case, it's the court that's going to drive it. So I'm trying to get a sense as to your experience there, and when do you think we're really looking at if this is sent back for a motion, if you have a sense?
My understanding is that if the lower court receives an order from you, that would, be very significant, and that would be prioritized by the judge and the clerks. But I'm sorry, I can't say more than that.
Sorry to interrupt you.
Okay.
I guess I'm not seeing, like I said, usually we see these much earlier in the proceeding. I'm not seeing the benefit of staying the appeal. So let's say hypothetically we were to vacate the decree, then everything goes back, right? And then the current circumstances would all be presented at that time.
That's
Even
correct.
were we to affirm, I'm not aware of anything that would prevent the mom from filing the 60B motion anyway.
Your Honor, my understanding is that, well, first of all, if you vacate the termination, I'm totally satisfied on behalf of my client. So if you tend not to do that, but you wanted to stay it, that would also be okay. But as for whether mother could file, I mean, mother will be struck of counsel as soon as the appeal is over. She will have no standing. At best, she could be a witness. And I have never seen I know my brother suggested it under a 11929B motion that somehow I could unvacate a parental termination in a permanency hearing. There's no case law. I mean, if the court was...
She doesn't, the counsel issue is a good point, but she doesn't have standing to participate in things such as review and redetermination, but she does have standing to file a motion as to the decree that terminated her rights.
Justice Shin, are you suggesting under like ineffective assistance of counsel or?
It's a decree that affects her parental rights. So I don't see why, just because we affirm, were we to affirm hypothetically, she would lose standing to challenge that decree.
My understanding is that is the general practice in the juvenile court, is that once a parent has their rights terminated, they are a stranger to the court. They could be possibly brought in as a witness or possibly as a guardian. You could possibly nominate them as a guardian, but in terms of, they're no longer a parent. They're stripped of all of their legal connections.
What happens with ineffectiveness claims?
Pardon?
What happens with ineffectiveness claims?
It's a very steep hill to climb.
I know, but how does it work procedurally? They let the mom file the motion?
I could file a motion. Well, no, I can't file a motion because that would be my client. I think that's a good question. So technically, right, mother's motion for an ineffective assistance, again, such a heavy lift other than the one. I think that I just want to say that my client's desire is that he would get his mother back. His desire is that he would have people in his life. That's what we're talking about. And I think that some of these other remedies that I've never seen be able to play out, having that happen, I would be, very concerned that it would be a dead end.
Okay, thank you, Counsel.
Okay, thank you very much.
Good morning. May it please the court, Matthew Price on behalf of the Department of Children and Families. Concerning the stay, the department would oppose the stay. I don't see the purpose for this court to hold off on a decision. As was discussed earlier, a 60B motion can still be brought below if this court were to affirm the lower court's termination, and in the event that this court doesn't affirm the lower court's termination, they essentially have their relief. Before a stay can be granted, there should be a likelihood of success, which I don't think is here, no other remedy, which is here in the form of the 60B, and irreparable harm, which is not present either, I would argue, because of the reasons already mentioned, that they can go back on a 60B and, or they get the relief if the...
As far as the irreparable harm, what do you say to the argument that we can do what we want up here, but as a practical matter, the mother's not getting back in the juvenile court in this case. They're not going to entertain the 60B if we affirm. What about that? Because we do, I mean, I understand we deal in the legal niceties here, but these folks go back down and live in the real world, so. Right, that the mother wouldn't have any real avenue to pursue a 60B if we affirm the judge's decision at that point.
Yes, they would be able to file the 60B. They might have it might be a challenge. I think in any case, it's a challenging thing for them to win on.
She'd have to do it, I presume, as a self-represented litigant, because her lawyer wouldn't be her lawyer anymore, right?
That could be.
Okay.
That could be, but that's the remedy that she could go back with. That's the action that is still available.
So I'm just asking, I mean, your experience, if you're in those courts, as a practical matter, is it 1% or more like kind of a 50-50 that you could even get a judge to entertain a motion?
I couldn't say for this court, as far as my experience.
Counsel, do you intend on filing anything written in opposition to this stay, which you're certainly welcome to?
Yes, I hadn't planned on it. I was just going to address it today.
That's fine. If you wanted to file something, if you could do it within a week, you're welcome to file something.
But you don't have to.
You don't have to.
Thank you.
Just after a week, we're going to assume if we don't have something that it's not coming.
Yes. As far as there being a low likelihood of success...
Can I stop you for one minor second? On the motion to correct the record, is there any dispute on that? There was a second motion that was also filed along with the motion to stay. Did you see it?
Yes. I think as far as the fact that Attorney Blanchett was present to that point, we can stipulate.
Okay. Thank you. Sorry to interrupt you.
The likelihood of success is low, given it's beyond a reasonable amount of time to bring such a motion, and as well as post-trial events that involve parental change in their circumstances have been found not to support reopening a case. That being said, also, divorce alone would not be dispositive of fitness, and it also doesn't necessarily show that there was a break in a pattern of taking up with abusive partners, which there's
Well, this all requires factual development, so why shouldn't the judge be given the opportunity to consider the changed circumstances?
You mean to file the 60B?
Well, either through a 60B or in getting to the termination point under adoption of Ramona, which seems to be pretty factually analogous. The judge was supposed to make, in my view, more detailed findings than she did about why it would be in the best interests of this child to terminate the mother's parental rights. So if, in fact, there are changed circumstances and the judge did not make detailed findings in the original decree, in her original decision, shouldn't this be sent to the judge to consider?
No, I don't think it should. I think that the facts before the judge and what the judge had to decide on were strongly in favor of what took place.
Can you point specifically to which facts we could read regarding how it is in this child's, putting aside it's not in the child's interest to be with the mother, there's, assume for the moment there's plenty of that, but why it's in the best interest of the child to be in the position the child was ultimately placed in?
To be placed.
Yeah, which is really kind of in nowhere land, to use a kind of a colloquialism.
To be placed in foster care,
Yeah.
you mean?
Well, no,
Well,
why is it in the child's best interest to terminate?
Well, I think that there was evidence of mother's unfitness. She did not put the child first in.
That explains to me why it's not in his interest to be with her, but why is it in his best interest for the termination?
To terminate was to give, that puts the child one step more forward in a direction of permanency, to be placed, to be in a place that's stable, rather than the uncertainty of ongoing potential litigation that mother could bring.
I mean, okay, so in Ramona, you had two boys who at the time of trial were almost 12 and could prevent their own adoption. They had a bond with the biological mother. They had no bond with another caretaker. And we vacated because in that situation, the judge had to make more detailed findings about why it would be in the best interest to terminate parental rights. How is this case distinguishable?
Well, in this case, in 2019, mother stipulated to her unfitness. When the review and redetermination trial started, the judge was in a situation to look at as far as what's changed as far as her being unfit. And from 2019 to 2021, when the trial took place, nothing had changed. She was still in the same relationship that had domestic violence and had a long history of domestic violence.
That goes to the unfitness inquiry. Termination is a separate inquiry, right? And I still haven't heard why it would be in the best interests of this child to terminate the mother's rights. Accepting that the finding of unfitness was supported by the evidence, the judge still has to go to the second step and make findings why termination is appropriate. And that's what I'm not seeing in her decision.
I think termination was appropriate because she had done at least some services as far as remedying her unfitness to be a placement, and that had not had any substantial effect on her situation, and that was prognostic evidence that that was just going to continue. She was going to stay in a relationship that would be detrimental to a child being in that situation. Housing was at risk. The children, when they were with the mother, were not the priority. That was not in their best interest to be with her when she was acquiescing to her abuser in that situation. And given the time that passed, there was no reconciliation and warranted termination.
So you have a child who seems unadoptable for, if no other reason, because he's going to block it. So again,
for no other
he
reason?
can't be adopted because if for no other reason, he's going to block being adopted, and he has the legal right to do that. So you said the reason to terminate is to get permanency. What kind of permanency can we get by termination that we can't get without it?
Well, it's one step forward to some kind of certain resolution. Just because, and I wouldn't necessarily concede that there's no outlet as far as adoption or some kind of long-term placement, but that doesn't mean that the appropriate alternative is back to a parent who
you keep arguing as if the only things that can happen is that the child be returned to the mother or that the rights be terminated. But you know that's not true because one of the children in this very case, there's no termination in a permanent guardianship. So it's not like those are the only two options. We can do something other than return the child to the mother without terminating if termination isn't in the best interests of the child. So you really have to give us some reason why it's in the best interest of the child, that don't assume that the alternative is mother immediately being the caregiver, because that's just not the only alternative.
The plan that was proposed before the court was not the guardianship for this child, it was for termination. And that's what the judge was considering as far as what was the best interest. Given the situation that mother was in, that, the child wasn't going to be returned to her given that circumstance. The guardianship was not a plan that was presented in this case for the child.
Right, the plan is, this social worker is confident that where parental rights terminate, an appropriate adoptive home will be identified. That sort of breezy optimism is the entire plan we got, that as far as I know is the only reason supporting termination, is this idea that there could be an adoption that, as far as I can tell, is completely impossible because the child can and will block it. So how can we affirm that plan?
The plan that the plan that was presented as far as what the judge considered was fluid, I guess I would say, at the time, given the child's situation. The child came from a residential treatment program at the time of trial and had just arrived at a foster care place.
Does the child's fluidity excuse the lack of detail? Well, let me ask you this first. Do you concede that as compared to Zarissa, this plan was wanting for detail?
I wouldn't go that far.
Okay.
I mean, the plan was, and it was going to continue to be followed by the court, that the child was in a new placement, and it would have to be determined how that worked out. If the child,
I don't know why you're saying that. I'm looking at the plan right now. Under the word plan, it says the plan for child is adoption via recruitment. I don't see anything about what you're saying. I mean, this is the plan document, and that's what it says for the plan. Where does it say any of this other stuff?
well, I'm sorry, can you repeat the question?
I'm looking at the plan, and we're on record 575 under the bold underlined plan. The next words are, the plan for child is adoption via recruitment. So that's the plan, right? That was presented by DCF.
That was, yes, that was part of the plan.
Well,
And-
okay, what else is in the plan? I mean, I'm looking at the plan. Tell me what else is in the plan.
Well, the child, before they could put together a, which I think is what you're getting at, is the specificity of the family that he's supposed to go to, he needed to be in a stable position. In order to do that,
All right, but how can the plan, if the plan is adoption via recruitment, and the child has the right and the intention to block any adoption, how is that an adequate plan? Regardless of the specificity of which is non-existent, of who's going to adopt.
the child having the ability to block the plan, I don't think precludes the department from following through on trying to get a long-term placement for him. And the only way to do that was to figure out what the circumstances that he needed to move into a long-term.
All right, well, if the secret plan is a long-term placement without adoption, how does termination help you get there?
Termination would be one step further in getting him some kind of certain situation, which clearly there are hurdles to, And
Wait, well, explain that to me. How, if the plan is a non-adoption permanence, how is termination even a step forward in that? Why is that a step forward in that? Why does that get you closer to that than you are without doing that? Step forward would get you closer, right? So how is that a step closer?
by terminating parental rights, that's a step closer to an adoption plan.
Okay, I understand why you need termination to adopt, but you keep telling me there's other kinds of permanency, and I don't understand why termination helps with those. I mean, the answer is it only helps for adoption, which is fine. It does. Let me try it this way. Is there any way, if we decide adoption isn't feasible, is there any way in which termination helps with getting a non-adoption permanency?
Yes, I think it does, as far as ending any future ongoing litigation that mother would bring. But as far as that goes, I mean, I would leave with the court that under Sharissa, the concurrent plan that was approved and the ongoing oversight of the juvenile court, given the circumstances, was appropriate. If there's not any further questions, I'll rest on my brief.
Okay. Thank you, counsel. Thanks to all of you. That concludes today's sitting. Thank you to our court officers, our clerk's office staff, our timekeeper. Court is in recess.
All rise.